Hey guys, before we get started today, I wanted to just take a second and give a sincere thank you. Obviously, this is episode 100 of our live show, and this is a channel that isn't even quite 10 months old yet, and we've passed the 20,000 subscriber mark, over 11 million views, over 1,000 videos, and more importantly, I would argue one of the best communities on the internet has evolved here. And I just want you to know that every day is appreciated. Nothing is ever taken for granted. And I'm very thankful to all of you for helping me build this wonderful thing. So again, thank you. It's episode 100. Let's go have fun. And as they say, let's roll, nerds. Happy Tuesday. Welcome to the Courtroom Files Live. Let's start our day with first appearances in front of Judge Mercer.
Both of us at the courthouse?
Yes, sir.
Great. Angela Trim is our first case. I apologize. I'll take Mr. Bravatt next. Ms. Trim, come on up. Ms. Trim, you're here for first appearance, ma'am, accused of, you've got two issues. You've got a child support issue, ma'am, with a $2,300 purge. In addition to that, you're accused of violating the terms of your state probation, and there's a no bond warrant in that case, Ms. Trim. Well, actually, Lieutenant, what was sent to me from the jail is not the warrant. What was sent to me from the jail is the affidavit. Do y'all have the warrant at the jail, Lieutenant? So, Ms. Trim, I opened the file up because an affidavit's not sufficient to hold you. So I looked in the court file, and in the court file, there is a warrant, and there is a no bond warrant signed by Judge Garcia. So I'm going to go ahead and arraign you this morning. I just want to make sure the jail has a copy of that warrant for their files. Ms. Trim, if you want an attorney appointed to represent you in this VOP, then that's what I'm going to do. Would you like to have an attorney appointed to represent you, ma'am?
Yes, sir. But may I say something?
I understand. Mr. McDaniel sent a text that says you think there's a global resolution to this that resolves this. That may be true. There may be some agreement I don't know about. There's nothing in the court file at all showing this has been resolved. So when you get to felony court here, ma'am, your attorney was Mr. Aldridge, I think. Is that
Yes,
right?
sir. Yes,
Mr.
sir.
Aldridge, the order says, the plea agreement in that case says concurrent. Concurrent means that a judge can sentence some of you to concurrent with all files at all showing this has been resolved. He or she cannot sentence you to something concurrent with a sentence you don't even received yet. So a couple possibilities. Number one is that Mr. Aldridge had a plan he's talked to everybody, he's talked to the judges and the prosecutors, and everybody's on the same page. And when you get to court, it's just got to be done. Everybody's on the same page. It's just your sentence hasn't been imposed yet, but there's an agreement reached. Choice number two is what the paperwork says, which is there was agreement on any prior sentences, but not future sentences. And I don't know which, but I want to get your lawyer appointed if you want one, so we can get your case moving. So would you like to have an attorney appointed to represent you?
Yes, sir.
I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel. We'll give you a court date and we'll see if you have any questions.
Okay.
Your Honor, we're going to enter plea of not guilty. Ask to set this in the next pretrial, August 21st, and I advise for Ms. Green to come by and talk to her at least before that hearing, probably before that.
Thank you. And Mr. Mitchell, anything from the state?
No, Your Honor.
So August 21st, Ms. Trim, do you have any questions?
No, sir.
All right, man. Wish you the best.
Thank you.
Mr. McDaniel, thank you. Mr. McDaniel, I skipped Arthur Pravat by mistake.
All right, well, he's between contestants. Good morning once again. Welcome to the Courtroom Files Live. I would like to direct your attention to the pinned chat, where you will find that we now have bingo. Take that, all my competitors. I dare any of you to find a bingo game on any other court channel. tcfbingo.com. Go ahead and pull that up in another browser or another tab on another device, whatever. Watch court, mark squares as you find stuff happen, and compete against your friends. A new way to interact here on the channel. Enjoy, guys.
And we looked up one case this morning, and I got to the office late, but with the help of Mr. Gill, I was able to find the case of State v. Brown, 725 SO2D.
You have more than one copy of that?
I just got the one copy right here. Okay. Hold on, 441. Specifically, the case was about, the impairment, and they say this, and I'll just read it in total. whether a person has consumed sufficient alcohol to be deemed under the influence or impaired to an appreciable degree is a judgment call made by a police officer. It must be based on objective facts and circumstances observed by the officer at the time and place of, in this case, the accident or the incident, and reliable information given to the officers by other. Further, Florida courts require that the underlying facts, circumstances, and information be sufficient to allow a person or reasonable caution to make the probable cause determination. Your Honor, in this situation, we have the deputy showing up to the mom's residence. She provided statements that, Mr. Pravat had been drinking and, led to him going out and making contact with Mr. Pravat. He observes him get behind the wheel, crank up the vehicle. He smells the odor of alcohol, observes his bloodshot eyes, I think is what it was. Red, runny eyes.
Yeah, runny eyes is what he said, yeah.
And he has reasonable suspicion that he's committed DUI, so he asks him to do the standard field sobriety exercises. He refuses, and he has to, he advised that he didn't understand, so the deputy had to explain it 2 more times, and Mr. Pravat just said he didn't understand and sticks his hands out saying, just, go ahead and arrest me at that point, and he has to explain to him 4 to 5 more times. And we contend that, this is the multiple explanations as an objective observance or an objective circumstance that the deputy is observing, showing that, there looks like there's impairment. There looks like, normal faculties are, impaired. Normal faculties, and we just had a trial about this, is ability to see, hear, understand instructions, walk, talk. And the fact that he's having to explain the instructions 4 to 5 times.
It's not what a complaint says, Mr. Mitchell.
What?
You want to read the complaint again?
He explained the reading for his investigation approximately 4 to 5 times.
No, you got to read the whole sentence, Mr. Mitchell.
We'll re-explain this. Arthur held out both hands directly in front of him as if to be placed in hand restraints, handcuffs. Arthur continued requesting that I explain the reason for my investigation approximately 4 to 5 times. Okay, yes.
Which I refuse to do so is the rest of that sentence.
Yes.
So that tells me he wouldn't explain it to him. It's not that he did explain to him 4 or 5 times. The officer refused to explain it to him is what the complaint says.
Misread it on that one, but he still did have to explain it 2 times, which the previous sentence did say so.
So make sure I understand your argument. So the elements that would indicate to a reasonable person that he was under the influence of alcohol to the extent his normal faculties are impaired are
that he
smelled of alcohol, that he had, I think he calls it watery eyes, and that he explained to him at least twice something. Let's see what he explained to him twice.
Arthur advised
he did not understand what I had explained. That he would be placed under arrest if he refused field sobriety exercises.
To which he repeated himself 2 more times after that, to which he just, put his hands out.
The elements his normal faculties are impaired are those.
Yes.
Are there other elements in the complaint that his normal faculties are impaired?
We just say take into account that he refused at that point.
I don't think refusal is something I can consider. In fact, I know it's something I can't consider. He has a right to refuse field sobriety exercises. Anything else?
Am I missing anything? That's all right now.
Mr. McDaniel?
Yeah, I think you pointed out most of the issues with it, but I mean, outside of that, it appears the officer, I know that the officers I've had to deal with the mother and the son before, and I know they have their issues and whatnot, but it appears the officer just going after him to do whatever he can to, and I have no problem if someone did something wrong, but this right here seems very, he's sitting in his driveway, he's sitting at his house. It's a vehicle that's not registered. That's an off-road vehicle just for the farm. He's not driving nowhere. It seems like more or less he's just nervous because the police are out there. He turns the vehicle off as soon as they walk back over there to his vehicle. If he's not going nowhere, it seems like a little bit, the officer may have took some kind of personal about this case. Because I don't see anything there.
Mr. Pravat, Florida law provides that the officer has to allege in the complaint for DUI the basis for the arrest. Mr. Pravat, he has to allege enough in there to lead a reasonable person to believe that you may be guilty of the crime you've been accused of. The Florida statutes even define normal faculties. That's the whole key in this one, is normal faculties are the ability to walk, talk, speak, make judgment calls. There's nothing in every case I've ever seen since I've been a lawyer and a judge has things like slurred speech, swaying, not being able to stand, or driving patterns like swerving in the lane or a crash or did not braking quickly. There's usually some bloodshot eyes. This one says watery eyes. What I'm finding this morning is watery eyes with a smell of alcohol. That's evidence that you have been drinking. That is not sufficient evidence for probable cause that you're impaired. Florida law does not, it's not a crime to drive while drinking in Florida or having drank alcohol. It's a crime to drive while your normal faculties are impaired. It has to do with the amount of alcohol and how it's affecting your system. That's no probable cause in this case. There may be some things they left out. I have no idea, but what's in this complaint is not probable cause that you have committed the crime of DUI. So I'm going to find no probable cause. That does not mean the case is going to be dismissed. Mr. Mitchell's office has the opportunity to try to get the officer to do a more thorough complaint and put in there additional bases, if there are any, for the DUI. But what I have now is not enough for me to think a reasonable person will believe that your normal faculties are impaired. You've consumed alcohol to that level. Again, there's evidence you were drinking. No problem with that, but that's not a crime. Normal faculties is the problem, and I'm going to find no probable cause. So, sorry, make sure my ringer's off. So the question, Mr. Pravat, is what do I do in this situation? I have two choices. When I find no probable cause, I can order that you be released, or I can hold you 24 hours and ask the state, give them a chance to amend the complaint if they wish to. I'm not going to hold you on this kind of charge with this kind of complaint when you weren't on the roadways. What I'm going to tell you is the state may fix this, and if they do, you'll get a notice to appear in court. My suggestion is you make sure the clerk of court has a good mailing address for you. You're going to be released this morning. You also need to understand this is an alcohol-related charge, so if you get another charge while this case is still hanging around or while it's still pending, then obviously I'm going to take that into account. There appears to be an alcohol issue, Mr. Pravat. You need to stay away from alcohol would be my suggestion. Mr. Pravat, do you have any questions?
No, sir.
Let me ask your sister, do you have any questions, ma'am?
No, talking about the bloodshot eyes, he's blind in one eye, so, and his other eye that he can't see out of, he don't open very much, so I don't understand much.
Yeah, and
And it was dark too, so.
there may be other things I don't know about, but I've explained it the best I can. The officer has to allege that his normal faculties are impaired, and asking to repeat a question and smelling like alcohol, that's not enough. It's not even close, in my opinion. Now, if he was staggering, if he was mumbling his words, if he was a driving pattern, that would be different. None of those things are in this case, though. All right, so you're going to be released this morning, ma'am. You can pick him up at the jail. He'll be processed out, okay? Are you going to be able to pick him up?
Yes, sir.
Your sister says she'll pick you up, Mr. Pravat. Any questions?
No, sir. Thank you, Mr. Mercer.
Yes, sir. Wish you the best.
So thank you.
Yes, ma'am. We have Corey Pittman.
So as of right now, it's no PC and he was released on an ROR.
Yes.
Okay.
Yes. Thank you, Mr. Mitchell. Mr. Pittman, good morning. Mr. Pittman, you have a hold for Washington County. Mr. Pittman, I took a look at the warrant out of Washington County, and there's no bond on that warrant. You're going to be held until you can get over to Washington County. When you get over to Chipley, sir, you'll go to another first appearance, and the judge over there, most likely be Judge Peel. That judge will address your case and decide if you're entitled to a bond, but you don't have a bond at this point. Mr. Pittman, any questions?
Do you know when I will be in Washington County?
I don't know. I can tell you that it could be as early as today, since they're a neighboring county. They may get you over there today. If not today, I would expect you to be there next working day or two. I expect you to be there. Today's Tuesday. I would say there's a good chance you're going to be there in the next 2 days, possibly
Yes, sir.
today. Okay.
Yes, sir.
Have a good day, sir. William Anderson. Mr. Anderson, good morning. Mr. Anderson, you're here before first appearance. You've been accused of 7 charges. You've been accused of 1 count of criminal mischief, one count of trespass, one count of grand theft, one count of fleeing or attempting to elude law enforcement, a driving while license suspended, a tag attached not assigned, and a resisting an officer without violence. I read the complaint at least 3 times trying to figure it all out. There's probable cause for some charges. On some charges, there's absolutely no probable cause in the complaint. I want to see what the state's position is on, in general, and what the state's request is given the circumstances. Mr. Mitchell.
Your Honor, I believe that, we were looking at it, and I guess for specificity, there was probable cause issues concerning his suspended license. That was the first one.
No, there's no evidence that he's the one that damaged the lock, the criminal
Okay.
mischief,
So,
other than being there.
okay, I was looking
The
at.
trespass, it's implied, but it doesn't say that the area he was in was an area that he didn't have permission to be, or it was inside the fence. I kind of implied, I might would say that's close enough. The grand theft, I think is close enough. There's video evidence of that. The fleeing or attempting to elude is close enough. Driving suspended license, they never say his license was suspended. No PC on that.
Okay,
And the tag attached not assigned is the worst one. There's no evidence at all that he's the one that attached the tag.
okay,
So there's at least 3, there's no probable cause. The resisting without violence, I think there probably is.
okay. So,
So what's the state's position?
Your Honor, we would request that, well, I'll start by also saying that I believe there's currently a warrant out for him in case number 25343CF also. So that's probably some other charges that he's going to have to be first appeared on. So we would just request 24 hours to amend the complaint to include some more information, possibly, have in some of the investigators that were currently on the property after the chase happened. They may want to add some more stuff that they found in there, just to give us a chance to amend the complaint, find PC, and possibly have that warrant served on him for the case that was filed on yesterday.
Thank you. Mr. McDaniel?
I don't have any objection, Your Honor. I mean, that sounds reasonable.
Yeah, there was a warrant signed. The other case you're talking about, the warrant was just signed yesterday afternoon.
Yes.
So it may not have been in effect at the time this happened. So, Mr. Anderson, what I'm gonna do is I'm gonna find out probable cause, at least as to some of the charges, sir. But I'm gonna hold you 24 hours, given the facts Mr. Mitchell's already put on the record. There's another warrant we gotta deal with anyway. I will see you tomorrow. I'm gonna ask Mr. Mitchell to notify the officer that we need a much more thorough complaint, hopefully reviewed by a supervisor this time. And Mr. Anderson will see if they can get probable cause. I'd be glad to set a bond on the cases that they do it and get probable cause on, if you're entitled to a bond. And we'll also give them a chance to serve that other warrant. I'll see you in the morning. Mr. Anderson, do you have any questions, sir?
Sorry.
You know what I'm saying there? But we ain't gonna talk about that.
No.
So
I'm
specifically.
gonna just say, I want to make sure Mr. McDaniel can hear you.
Oh, okay.
Do you have any other questions, or you have, no question, John?
I mean, look at my
All right.
fucking shit, man.
Sorry.
I'll see you in the morning. Mr. Mitchell, you about to say something?
Yes, specifically so I can let the investigators and the deputy know the no PC is the criminal mischief, DWLSR, and tag attached, not assigned.
Those are pretty clearly no PC. The
Okay,
others
so-
are marginal, but I would find PC.
But you would find PC.
And the
Okay.
fleeing or attempting to elude, he needs to put in the body of the complaint that his lights and sirens are activated, not just in the charging section.
Gotcha. Okay.
The grand theft and trespass, the trespass needs to put he didn't have permission to be there. I don't know if his theory is that it's enclosed by a fence. It mentions a gate. I don't know if it's enclosed by a fence. It's either got to be enclosed by a fence or it's got to be marked with no trespassing signs. You know, the trespass statute has several ways. It just, what I was told is that supervisor didn't have time to review the complaint before it was sent in because they were involved in other things. And this complaint, I mean, it's a new officer. He's just got to learn. And the only way he's going to learn is if somebody shows him the right way to do a complaint.
Okay.
Thank you. That brings us to Rondre Hill. Mr. Hill, good morning. Mr. Hill, you're here because you've been accused of one kind of aggravated battery. Mr. Hill, I've read the complaint. In your case, there is probable cause for the charge. In your case, Mr. Hill, I'm a little confused about your criminal history. So the criminal history I was provided by the jail shows a very recent weapons offense, but when I tried to pull it up, it's a different name and a different date of birth. So I asked the jail for another criminal history. So then they sent me a second criminal history. I'm gonna ask you just a second. I think they sent me a second criminal history, and the second criminal history has your name and your date of birth and shows nothing. So I'm thinking you have no prior criminal history. Is that accurate?
Yes, sir.
Never been charged with a crime anywhere, correct?
No, sir. No,
Okay,
sir.
that's great. That's good to know. And how old are you?
18.
Okay, thank you. So that helps me. That helps me get started on a bond or release decision. The charge accused of is a second-degree felony. So I'm gonna see if the attorneys have any additional information before I make a bond or release decision. Mr. McDaniel, anything on behalf of Mr. Hill?
No, Your Honor.
Mr. Mitchell?
No, Your Honor. What was that just fell?
What was it?
I saw something fall from your desk
Oh, did
right
I?
there. Caught my attention.
Mr. Hill, you're 18. Are you a student? Are you employed or neither?
I get disability every month, but I'm not employed.
So you receive a disability income, correct? Is that what you're
Yeah,
saying?
I get Social Security.
Mr. Mitchell, what's the state's position on bond versus release, given his lack of history, but that's a second-degree felony?
Yeah, I would say that for a second degree felony, we would request a cash or surety bond, but if the court wants to go lower than usual based on his lack of history, I mean,
I think we think alike. So I was thinking that. What I'm going to do is I'm going to set you a bond for a third-degree felony. I'm not going to set you a second-degree felony bond, but I'm also not going to give you conditional release because the allegation does involve a gun, but it is not a firearm in the traditional sense. It is a pellet gun. Well, it actually says paintball, and paintball gun and pellet gun are two different things, but neither of them are firearms under Florida law. So what I'm gonna do is I'm gonna set you a bond of $2,500 cash or surety, Mr. Hill. You can go through a bondsman, sir. You have a condition of no contact with the alleged victim at all. Mr. Hill, you'll get to use the phone in just a few minutes, sir, to try to post the bond. If you post the bond, you'll be released. If you go through a bondsman, Mr. Hill, they would charge you somewhere in the neighborhood of $250 to get you out of jail. But you can have no contact with the alleged victim, no contact at all. If she tries to contact you, you tell her you can't talk to her about the case, can't talk to her at all, and discontinue the conversation. Mr. Hill, you'll get to use the phone in just a few minutes. Do you have any questions?
I got just one question. Like
Okay.
I got any charges like that's on me, like charge?
Yeah, that's what we're here for today.
Okay.
You're accused of one count of aggravated battery at this point. Yes, sir. That's what you're accused of.
They told me they didn't press charges though.
Sorry.
Uh,
All right, you'll get to use the phone in just a few minutes, sir.
the paintball gun still hurt.
Well, he's between contestants. Thank you, Barbara, for gifting that membership. Very kind of you. And Chubby and Peggy, welcome for all of you except for Mrs. TCF, who has no idea who that is. That is a friend of ours from our rabbit community. So welcome all the way from Jolly England. Let's get back to Judge, see what's going on. Oh, nothing's going on with Judge. He's done. Let's go to Alaska, see what's up with our bear friends. So we got one at the top of the waterfall today, and then there's one playing around right in front there, as you can see. So I'll let you guys stare at that for a moment and figure out where I want to go next. Judge ended abruptly on me. Let's go to Fulton County, Georgia. Eric Morrow doing their all-purpose calendar this morning. Let's go there.
Further contact with Morgan Villar. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state, and we would like to sound for Ms. Morgan Villar.
If Ms. Villar is with us and wishes to address the court, now is your opportunity. Does not appear so. Mr. White?
So stipulated, Your Honor, nothing further.
Mr. Felton, it's my understanding that in case 25 CR 003964C, you wish to plead guilty to criminal trespass. Is that correct?
Yes, still with my spot created. I'm just
Yes, that's right, sir. Stay away from that Spark Street. Are you under the influence of any drugs or alcohol this morning?
What they say?
Are you under?
No, I'm, what's they, it's 17, 18 hour broken look, so.
You're not under the influence of any alcohol currently, correct? No
Right.
medication, okay.
I had 4 months,
Okay.
4
Okay.
years, one night.
Now, Mr. Felton, you've been represented by Mr. White there. Are you happy with what he's done for you?
Come trespass. I'm supposed to be getting locked up.
Are you okay with my help? Okay.
Okay, Mr. Felton, listen to my questions, okay? So that we can get your correct answers to them. Mr. White's represented you there. Are you happy with what he's done for you?
Yeah,
You understand that you do have a right to a trial by jury on this charge, and by pleading guilty, you're giving up that right. Do you understand that?
yes,
Has anybody forced you to plead guilty?
no, they said, I had this salary before, yeah.
Okay. I'm going to accept the plea as negotiated. If he needs some services, Mr. White, I'm sure that we can get him some help with housing if that's necessary.
We discussed it yesterday, Judge.
Okay, very good. Good luck to you, Mr. Felton.
All right.
Mr. Bass, are you?
Yes,
with
are you
me?
able to hear me?
Yes, I can hear you now. Good morning. Let's see, you're here for Mr. Duffy. What are we doing with Mr. Duffy today? Okay, I can't hear you again. I still, I'm not able to hear you, Mr. Bass. For some reason, your sound keeps going out on us. Ms. Falk, do you know what we're doing with Mr. Duffy today?
Yes, Your Honor. Mr. Duffy is going to be a negotiated plea. He has already sent the paperwork to Ms. Champion and myself. So really, it's just a matter of putting the recommendations on the record and him stipulating.
Okay.
If you would go ahead while I can talk.
Okay, I can hear you now. So let me go ahead and address your client. Good morning. Good morning, Mr. Duffy. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Can you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court would be the truth, the whole truth, and nothing but the truth? Okay, you're on mute there now, courtroom 2.
Yes,
Okay. All right, very good. You can place your hand down. Thank you. Mr. Bass, can you hear us?
Yes, I can.
Okay, very good. Yes, Ms. Falk.
Yes, Your Honor. Starting with position number 18, state's recommendation on the criminal trespass is 12 months served 46 days, credit for time served 23 days from 11/26 to 11/29 of 2022, and then July 11th, 2025 until today. Balance suspended. Stay away from 811 Woodley Drive in Atlanta. No further contact with Miss Lindsay Johnson. And count position number 19, which is the theft of service. That's going to be 12 months served, 46 days, credit for time served 23 days from November 4th to November 7th of 2023 and July 11th, 2025 until today. Balance probated. Stay away from Chops Lobster Bar located at 70 West Paces Ferry Road, Northeast in Atlanta. Count 2, the criminal trespass will be 12 months concurrent with count 1. Stay away from 1 Buckhead Plaza, located at 3050 Peachtree Road, Northeast in Atlanta. The disorderly conduct will be time served, 46 days, credit for time served, 23 days. Count 4, the disorderly conduct will be 12 months concurrent with count 1. No further contact with Brian Jenkins. And count 5 will be 12 months concurrent with count 1 and a $300 fine. The case can go balance suspended. We will agree to let the case go balance suspended after the defendant has completed the conditions of the probation. And on the failure to appear, which is position 20 and 21, the state will enter a null pros upon the conclusion of this plea. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
Mr. Bass?
We stipulate.
Anything further?
We would ask, if possible, that the probation fees can be waived.
Okay, anything else?
No, Your Honor.
Okay. Mr. Duffy, it's my understanding that in case 22 CR 007980E, you wish to plead guilty to criminal trespass. And in case 23 CR 006905E, you wish to plead guilty to theft of service, criminal trespass, public drunk, disorderly conduct, and willful obstruction of law enforcement officers. Is that correct?
Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, absolutely. Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor, I do.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated. Mr. Duffy, I will have the probation terminate when you complete the terms. As an incentive to get through it quick, I'm not going to waive any fees, but as soon as you complete the terms, you won't have to be on probation and pay those fees. Good luck to you, sir.
Thank you, Your Honor.
You're welcome. Anything further this morning, Mr. Bass?
No, Judge. Thank you.
All right. Have a good day, sir.
There you are. Button issues. Anyways, perfect segue into what I want to do next. Today's show actually has a sponsor. Today's sponsor is Aura. So let's take a minute and talk about them. So Aura actually came to me about a month ago, and they're like, hey, dude, we found your channel. We love what you do. We'd love to partner with you. And I put the brakes on it because I'm like, I have no idea who you are and what you do. So they explained to me that they do things like protect your data online and stuff like that. So because you know me, I said, prove it. So they said, we'll prove it, but first go Google yourself. So I did, and the results were horrific. Not only is the data that I had online, my business stuff, which you would expect, but way too much personal stuff. So they gave me the product, and they said, now see what can happen. And we saw what could happen. All of a sudden, my data started disappearing online. So I want to read you this email that I got. This was just a couple of days ago, and it's from a company called Helix Campaigns. And it says, Helix Campaigns has received a request for the deletion of your personal information from our database. If you do not remember making this request, it may have been submitted by a third party on your behalf, likely a data privacy service. We processed and completed the deletion request for the information we have associated with your email in accordance with our obligations under applicable law. There's nothing further you need to do at this time. Please do not hesitate to reach out if you require additional assistance. Best regard, Helix Campaigns. Now, immediately, the first question I had was, who the heck is Helix Campaigns, and why did they have my data? So I went ahead and looked them up, and if you go to their website, it is one page with nothing clickable, but it does give you the opportunity to opt into cookies. Go figure. But my point is, I had no idea who they were, but Aura did. So that is one of the things that's proved to me that this whole thing works. So on your screen, you'll see all the different things that they offer, and that isn't even all of them, but it's most of them. Identity protection, transaction monitoring, spam and junk removal, antivirus. They've got a VPN, which is the same VPN I've used for years. It's really good. They have parental controls, spam call protection, which I'll talk about at another time. That's been a big benefit for me. They have a password manager, all sorts of things. And to be honest with you guys, it just works. So I've made an arrangement with them. If you go to aura.com/TCF, they will give you 14 days for free. There is nothing to lose and everything to gain. Go to aura.com/TCF. Seriously, sign up for it. See what it will do for you. Within a few days, I saw all of the different places where my information was online, and I saw them removing it, and I'm getting emails like the one I just read to you that shows how things are getting better for me. And I'm not just going to keep up with the service that they gave me to try. I'm going to become a customer because it honestly works. So aura.com/TCF, give it a try. Again, you've got nothing to lose and everything to gain. Trust me, it's worth it. Let's go back to Judge Morrow.
Morning, Mr. Brown. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can place your hand down, Mr. Brown. Ms. Falk?
Yes, Your Honor. On the DUI, 12 months served, 36 days, credit for time served, 18 days. From July 11th, 2025 until today, balance probated, 40 hours of community service, 2 victim impact panels, DUI risk reduction, ADET, and a $500 fine. Count 2, the recommendation is 12 months concurrent with count 1 and a $300 fine. Count 3 will merge with count 1. Count 4 will be 12 months concurrent with count 1 and a $500 fine. Count 5 will be time served, 36 days, credit for time served, 18 days. And count 6, which is the improper erratic lane change, time served, 36 days, credit for time served, 18 days. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. That's all for the state.
Mr. White?
Your Honor, we do stipulate for the purpose of the plea, just 2 requests. We would ask to enter a NOLO on the suspended license and improper or erratic lane change charges, and ask to convert his fine to 130 hours of community service, and ask the probation to go to non-reporting once he completes all of his requirements.
Okay, so convert the $500 fine to 50 hours of community service and NOLO on the suspended license and improper lane change. Has he pled NOLO in the last 5 years?
To my knowledge, no, Judge. And we were asking actually the entirety of the $1,300 of fines be converted.
The entirety of, okay, so the $500 fine, the $300 fine, and the 2 $500 fines.
Correct.
Okay, okay. Ms. Falk?
I'm just checking his history. It does not look like he's pled NOLO before in the past, so we don't have an objection to him pleading NOLO to the suspended license. And I'm not seeing any other suspended license charges for him. And as far as converting the fines and fees to community service, state has no objection.
Okay. So everything is fine, Mr. White. Anything further before I take the plea?
Nothing further, Your Honor.
Mr. Brown, it's my understanding that in case 25 CR 003971A, you wish to plead guilty to driving under the influence of alcohol less safe and willful obstruction of law enforcement officer, and you wish, and possession and use of drug-related objects, and you wish to plead NOLO to driving while your license was suspended or revoked and improper erratic lane change. Is that correct?
That's correct.
Are you under the influence of any drugs or alcohol at the present time?
No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty and NOLO to them, you're giving up that right?
Yes, I understand that, Your Honor.
Has anyone forced or coerced you to plead guilty and NOLO?
No.
Okay. I'll accept the guilty and NOLO pleas as negotiated. I'll convert the fines to community service. When you complete the terms of the probation, I'll have it go to a non-reporting status. Good luck to you, Mr. Brown.
Thank you. Thank you, Judge.
All right, let's change things up a bit.
Next
Let's
disposition, 28.
Oh, hush up. Let's go to Texas. We'll say good morning to Judge Stevens.
Yeah. Hi, buddy. These are 90+% of cases are disposed of this way. As long as it's not that case you said down, but. All right, 24DC CR 1589 is now called the State of Texas versus Mario Alexis Thompson. That's you, sir? Yes, sir. And you were here with Mr. Mitchell, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary? Yes, Judge. In summary, this indictment, sir, alleges in paragraph 1 that on or about June 1st, 2024, over a year ago in Jefferson County, Texas. You operated a motor vehicle in a public place while intoxicated. Paragraph 2, though, goes on to state that would have been otherwise a misdemeanor, except it goes on to state in paragraph 2 that you have 2 prior convictions of DWIs, operating motor vehicles while intoxicated. One, May 14th, 2003, out of the County Court of Law 2 of Jefferson County, Texas, and another one on February 1st, 2006, in the County Court of Law 3 of Jefferson County, Texas. Paragraphs 1 and 2 constitute a third-degree felony. Do you understand what you were charged with here, sir?
Yes, sir.
Okay. If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Here it is. Yeah, you can't make this stuff up. There's nothing. There's
Tablet.
nothing on it.
No.
Nothing going on with the tablet.
This is the continuing saga with our technologies.
Well, okay.
We're getting new tablets. We should make the paper. Phenomenal.
It's not working. You know,
I'll give you this one.
I need MI.
Is there another one?
Well, they need to come in and we do too much work. Too much work.
It's this one. Yeah, already pretty good. So you want to switch?
Yeah, I'll give you this one.
Too much work we do without having the pad trouble. That's just. Yeah. They were in here yesterday too, working on it. And overnight, it's gonna be all the taxes. Electronics.
I know it's.
This is a third-degree felony, which means if convicted, you face no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
What is the plan, the deal?
1005, Judge, or 1005. 10 years probably for 5 years, 1,000
All right.
weekends.
An agreement has been reached where you would be pleading guilty to paragraphs 1 and 2. Thank you. This is working.
That's right.
And you would be found guilty of this third-degree felony, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 5 years, fined $1,000. There would be other terms and conditions of probation, which are normal and customary for this type of offense. You must serve 10 days in the county jail as a condition of probation. And that we'll talk about when that begins. You will check in on or before 6:00 p.m. on Friday. They'll let you out on Sunday. Then you go back the next Friday. You've got to do that. I don't know if it's 3 weekends and a day on a 4th weekend or not. I'm not sure the way it's worked like that, but it could be 4 times.
Yes, sir.
With that last being an overnight stay. But whatever it takes to complete 10 days in jail. So is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this crime charged here, the DWI? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
And the second paragraph, which has those prior convictions of DWIs in 2003, 2006, out of County Court of Law 2 of Jefferson County, Texas, are those allegations true and correct as they are alleged in paragraph 2 of this indictment?
Yes.
And are you pleading true and correct to that voluntarily?
Yes.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes.
Understand it, discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. This states, among other things, that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. States Exhibit 1, part of the record for all purposes. Is a pre-sentence report waived here?
Yes, Judge.
I'm going to follow this agreement and find you are pleading guilty to paragraph 1 and true to paragraph 2 of this indictment, constituting the third-degree felony of operating a motor vehicle in a public place while intoxicated. You're doing that voluntarily, knowingly, intelligently. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes.
There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of this offense. I am following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 10 years. And that will be suspended. You will be placed on regular probation for 5 years. You must pay a fine of $1,000. There will be terms and conditions of probation which are normal and customary for this type of offense. You also must serve 10 days in the county jail that begins on or before 6:00 p.m. on August 8th, 2025, and each Friday thereafter. After you will serve weekends until 10 days are successfully served. Do you understand what has happened today, sir? The only other thing is, look at this pad, his signature on the bottom. I think it just didn't work.
Okay.
It's to re-sign, or at least complete that. It just,
And you understand that, there was some documentation you wanted to bring with you to the jail each time for them to admit you into the jail.
Yes.
Yeah, and we'll put you all. Yes. I'd say it, it's your team. Right here.
All right, you will stand by. So, I think there was a fourth page I missed. The additional terms of community supervision page.
Yeah, he's signing. Sign this last page on here.
Next Monday, we can start this weekend,
August 8th.
August 8th.
Thank you. We're signing away. Anything else on this one? Thank you. Looks good.
Yes, Judge, everything was good.
We have somebody in jail.
Yes, sir.
All right, thank you, Mal.
Never go against Mr.
Yes, thank you. You bet. See you, Brandon. Thanks, Judge. Yes, let me see that other case.
But you're still gonna need.
The bonus.
Yeah.
Let's begin it, Your Honor.
No.
Okay.
Where's the man?
Did our bond forfeiture come in?
Did the bond forfeiture come in?
I said 9:45 was the estimated.
No, we just have our
Arrival.
Oh, this is just the defendant.
Yes,
Yes, okay.
All right. While he waits for the next contestant, let's go down to Miami-Dade and let's check in with Judge Grumpy Pants.
Good morning, sir. You were arrested for possession of a firearm, weapon, or ammunition by a convicted felon in possession of MDMA, a controlled substance. I will appoint the public defender's office for you. Would you show a felony conviction for him?
It's there, Judge. It's that F08 7869. The tampering is an F3.
Oh, okay. There's probable cause for the charges. It may be a questionable stop, though. So I'm going to set a bond. Count 1, possession of a firearm by a convicted felon is $7,500. Count 2, possession of the controlled substance will be $1,000 while armed. All right. Have a nice day, sir. Next case, page 6, Desmond Green. Good morning, Mr. Green. You were arrested for possession with intent to sell cocaine, possession of a controlled substance called MDMA, possession of cocaine, possession of cannabis. And I will appoint the public defender's office for you. What happened to the traffic?
He's going over there now, Your Honor.
All right, give me a second to review. I think there's probable cause for all the charges. I'll set a bond as follows. I'm gonna just lower count one a little and I'll split one in two. Count one will be $2,500. Count two is probable cause for the possession of the MDMA, $2,500. Count three, possession of cocaine, $2,500. Count four, the possession of cannabis. And a marijuana cigarette. You want an ROR?
Yes.
Okay, ROR
Do you want
count
to
four.
do 5,000 on count one? split them one?
I'm not gonna do that. It was a traffic stop. He meant, he had a quantity that's a little large, but it also could be for personal use. I don't know how the state's gonna charge it. And I don't see him with anything recent either, so I'll give him a break.
All right, it's over state's objection.
So noted. Next, we have page 7 is Edgar Santiago Pagan.
Maybe tap.
Spanish, please.
Good morning, sir. You were arrested for possession of cocaine. I will appoint the public defender's office for you.
Señor, usted fue arrestado por posesión de cocaína.
Public defender's office is appointed.
La fiscalía le asigna a un abogado de oficio. Perdón, se le asigna un abogado de oficio.
So there's probable cause for the charge.
Hay causa probable para el cargo.
Tap alternate bond, $2,500.
Le dieron TAP, el programa, o si no, fianza $2,500.
You have to come back to court for your arraignment. What was it, the 28th?
Tiene que volver al tribunal para su comparecencia.
August 28th at 9 a.m., courtroom 7-3 before Judge Young.
Inicial, tiene que volver el 28 de agosto, sala 7-3, juez Yang.
Have a nice day, sir.
Que tenga buen día, señor.
Next, we have George Morales. Good morning, Mr. Morales. You were arrested for possession of a controlled substance called fentanyl. Problem is you're out on felony bond, so there's a hold for you to see the division judge tomorrow in case F254636. So it's a traffic stop. They found 15 pills, 3 grams of fentanyl. So there's probable cause for the charge. You're too close to even being a trafficking amount, but I'm setting a bond for possession of a controlled substance. It will be $2,500. Have a nice day. You'll see your judge tomorrow. Next we have is Giovanni Carbo. Page 7, bond out.
Bond out.
Where are all the bonding when we need them on those really heavy days? But I appreciate them being here today. All right, next we have, do you have any more forms for me? Thank you so much, Matt. We need Patrick Gaines.
Yeah.
Good morning, sir. You were arrested for 1 count of grand theft. I will appoint the public defender's office for you. There's probable cause, it's theft of a city bike. You are ordered to stay away from the 2100 Washington Avenue building. The building at 2100 Washington Avenue in Miami Beach, Florida. You're not allowed to go to that location. You must stay away from there, sir. Has an open case for petty theft. I'm setting the bond at $1,000. Good day, sir. Next we have is Ronnie Roque, page 8. Good morning, Mr. Roque. You were arrested for 2 cases. One is grand theft of a vehicle, charges a second-degree felony. The other case is dealing in stolen property. I will appoint the public defender's office for you. Inside the car that was stolen, they found a black ski mask. An iPhone charging in the center console that belonged to Mr. Roque. Victim said they left the keys in the car and forgot to lock the doors. They had CCTV of the car theft. In the CCTV video, you can clearly depicts Mr. Roque as the person who stole the victim's vehicle. There's probable cause for grand theft of the vehicle. I don't see the value of the Range Rover state.
No, so it would be a third.
Yeah, but I know, all right.
It's fine.
Let me see what the other case dealing in stolen property.
It's for the property that was found inside of the vehicle.
Oh. Numerous other keys and vehicle belongings. Okay. You are ordered to stay away from the alleged victim, Christina Gutierrez. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. You must stay at least 500 feet away from the victim, her home, school, and place of employment at all times. So I'm not giving him pretrial, but I'll be happy to do house arrest. It looks like he's involved in numerous thefts, given the items found in the car, or I could just do a straight bond. Stay, what would you like? He's 19. Are there juvenile priors?
Nothing I'm aware of.
Okay. You want house arrest, Ms. Corey? Because that's your best offer today for a non-monetary release.
Yes, Judge.
All right.
You would like the ability to work, Judge.
Oh, okay. House arrest with the GPS monitor, alternate bond on F25-16055 is going to be $2,500. And that's level 3 house arrest. I'm giving him a curfew though, 11 p.m. to 6 a.m. And then the other case is F25-16068, the dealing in stolen property. It's going to be house arrest. Alternate bond, $7,500, level 3 house arrest with the curfew, 11 p.m.
On the curfew, could you modify the curfew? He works until 11 o'clock at night?
Yes, ma'am.
And it takes him about a half an hour to get home.
Fine, it'll be 12 p.m. Is it 12 a.m.? Sorry, 12 a.m. to 6 a.m. 12 a.m. to 6 a.m.
So midnight.
12 a.m. midnight to 6 a.m. I don't want him out and about while he's on house arrest. Okay. Have a good day, sir. Next we have is Marco Guerrero. Good morning, Mr. Guerrero. You were arrested for aggravated assault with a firearm. This goes back to February 10th of 2025. I will appoint the public defender's office for you. Was it a road rage? He's pointing a gun at somebody in the other car.
Yes.
Sir, you were ordered to stay away from the alleged victim, Alberto Ibert. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties, and you must stay at least 500 feet away from the victim's home, school, and place of employment at all times. Do you understand the stay away order?
Yes, ma'am. Yes,
All right, thank you. All right. It goes back to February 10th. He's 20. I don't know what you want. Does he have money
For a
to,
bond.
does he have money to post the bond?
Judge, he does landscaping work. Would you be able to do 2,500?
Okay, sir. I'll set your bond to $2,500. Make sure to keep all future court dates. Stay away from the victim. You pick up a new law violation, you can get rearrested, and you'll be locked up in jail until your trial, okay?
Okay. But I was
Don't talk about the facts, only speak privately with your lawyer. Corrections or anybody, do you know if there's somebody on court for Sean, is Sean Valendia in court? There's an attorney here who wants to know. F25-10262.
One second, I believe it is on calendar, but it should print in division. We can call it out of turn. It's about 5 defendants down.
Okay, let me promote the attorney. So if the attorney would raise their hand, I'm happy to promote you. Thank you. You missed me? You found me. Oh, I thought you missed me. I miss you.
Join as attend, stay as attendee. Am I in or did I just?
Hey, sir.
So just put on your Zoom. You can accept a promotion as a panelist.
Okay, I gotta, join
Fine.
as a panelist.
Join as a panelist. Let me find the paperwork. 1 second.
You ain't gonna have it because it's off calendar.
It's gonna be off calendar.
Tomorrow.
So I'm told it's off calendar and should be in division tomorrow.
And division is Judge Zachary James, correct?
I don't know, what's the name?
I
They're
believe
telling
so.
me yes.
Courtroom 4-5.
I was there today. The family just called me all harried because he got pulled for your court, and I told him it was going to be tomorrow in front of the division
So
judge.
what happened was he had an arrest warrant for his illegal trafficking and drug case. And so it's going to be heard tomorrow morning before Judge Zachary James. I won't be there today.
No, I was there today already, Judge, and checked. I've been back and forth from Miami already.
It printed here. So we're going to take it for the record. Sean Barreno
Valandia.
is going to be off calendar and it should be printed to transfer to division for tomorrow.
Okay, thank you, Your Honor. It was
Yes,
nice
sir.
to make your acquaintance today. Now I know
Thank
how to
you.
get promoted. I appreciate that.
Raise your hand or call my JA like you did. Thank you so much.
Thank you. You have a pleasant day. Thank you for your help and your time.
Thank you. Do I say off calendar or just transfer to division?
You said transfer to division.
Okay, transfer to division. All right, next, I'm sorry, we have your Lever Matos on page 8. Hi, Mr. Matos. Is he here or no?
The bond out, Your Honor.
Oh, bond out. Michael Lorenzo is next.
He's present. He indicates he has funds for an attorney. He thinks his mom has hired an attorney for him.
I don't know, is a mother here?
What's your mom's name?
Oneida.
Oneida is.
Do you speak English, sir?
Yeah, I speak English.
Sir, you were arrested for a case from June 12th of 2025. The charge is strong arm robbery, grand theft, a second-degree felony, and battery. So you sure you can afford to hire a lawyer?
My mom, yeah, I believe so. My mom.
Are you hiring one or your mother?
My mother.
Okay, are you working?
Yeah, I'm working.
How much do you make a week?
A week, 800. Bi-weekly, it's 1,500.
I mean, I'd probably appoint the public defender if I think you're eligible if you want one, but I don't know, if you say you hired a private lawyer, then I can reset it for you, whatever you like. Or you can waive a lawyer's presence and hire one after you get out of jail.
Can I do that option? Can I hire a lawyer after I get out?
Sure, sure. So are you okay waiving a lawyer's presence for purposes of this hearing?
Yes.
All right,
He
this
has
is from,
Thompson here now, Judge.
okay, sir, are you currently living with the alleged victim, Cynthia Castro?
No.
Okay, thank you. So let me just review for probable cause. So it's not, it's a third degree grand theft. There's probable cause for strong arm robbery, grand
He's
theft.
charged with 2 strong arms, though, Judge.
Oh, 2 strong arms? What, for the lanyard?
I don't know. So it's right. So initially, right, he pulls on the purse, grabs the lanyard, and then took the car. And then she gets into a different vehicle. The next incident happens at the gas station where he tries to take her out of her car. He then throws her keys on the ground and then runs.
So that's not only 1 strong arm.
I
How's it
think
2?
only one. Well, this,
Could be a burglary. I don't know.
yeah.
Anyway, so you are ordered to stay away from Cynthia Castro, the alleged victim. No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. You must stay at least 500 feet away from the victim, her home and school, and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay away order, sir?
Yes.
All right, so count 1, there's probable cause for strong arm robbery. Wait a second. State what bond do you want?
5,000's okay.
All right, count 1 is a $5,000 bond. Count 2, there's no probable cause for strong arm robbery. Release outright. So count 3, there's probable cause for grand theft of the vehicle, $2,500, and count 4, battery is $1,000 bond. I'm told you have a bondsman here, and that bondsman will be able to get you out of jail. Have a nice day, sir.
Thank you.
Thank you.
So while she's between contestants, I'm watching the funniest thing right now, but I don't have it set to pull up. Judge Belersian in Allegan County, Michigan is about to retire, and he is being shadowed by who I assume is his replacement. And the Zoom feed keeps cutting off the head of the guy who's shadowing him. So there's like this headless judge sitting behind him. It's hilarious. I'm going to have to try to pull that up for you guys.
Yep. So I will appoint the public defender's office for you. I need a review. So there's probable cause
Count 1.
for count 1, the armed burglary with an assault or battery. Wouldn't count 2, the better charge, be throwing or shooting a deadly missile? He's
I mean, I
shooting
figured Your Honor would find PC for aggravated assault with a firearm.
or aggravated assault with a firearm. The victim's driving away and the defendant fired 1 round, striking the passenger side. Sir, you are ordered to stay away from Xavier Lopez, the alleged victim. No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. You must stay at least 500 feet away from the victim, his home and school, and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. Do you understand the stay away order, sir?
Yes, Your Honor.
All right, anyway, I'm granting the state's motion for pretrial detention pending final hearing as to count 1, the armed burglary with an assault or battery, that's no bond. Count 2, there's probable cause for aggravated assault with a deadly weapon. That it could also be throwing or shooting a deadly missile, but that's gonna be $5,000 for count 2. In count 3, criminal mischief, there's no it's armed criminal mischief because you struck the vehicle, so that will be $2,500. We'll see your judge tomorrow. That judge will set a final hearing on the state's motion for pretrial detention. Our next case is Yasmin Nordars. Good morning, sir.
This is an added charge, Your Honor.
Sir, you were arrested for grand theft, a third-degree felony. I will appoint the public defender's office for you. So he's stealing a bicycle. So is there value?
I didn't see it.
No, Judge.
No value. You are ordered to stay away from the property where this incident occurred at 7928 West Drive in North Bay Village, Florida. You are not allowed to go to that location and you must stay away from there. The bond will be $150. There's probable cause for petty theft. Next we have is Abi Bonilla Ortiz. Good morning,
Spanish,
sir.
please. Spanish.
Sir, you were arrested for an attempted aggravated assault with a deadly weapon. I will appoint the public defender's office for you.
Señor, usted fue arrestado por un asalto agravado con un arma mortífera y he asignado a un abogado de oficio para usted.
Your Honor, he has a hold for immigration.
Tiene una retención de inmigración.
Right, so there's probable cause for aggravated assault with a deadly weapon. It's not an attempt.
Hay causa probable para asalto agravado con un arma.
Sir, you are ordered to stay away from the alleged victim, Julissa Guzman Gallo.
Señor, usted se le ordena mantenerse alejado de la víctima Yulisa Guzmán Gado.
No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
No tienen derecho a tener ningún tipo de contacto directo, indirecto, por teléfono, por escrito, a través de terceras personas o por texto.
No contact with the victim through social media or other electronic means.
No puede comunicarse por redes sociales u otros medios electrónicos.
And you must stay at least 500 feet away from the victim's home, school, and place of employment at all times.
Tiene que mantenerse por lo menos a 500 pies de la víctima, de su lugar de trabajo, de residencia
Do not engage, sorry.
y el lugar donde trabaja.
Do not engage in any criminal activity. Do not use or possess illegal drugs.
No se involucre en ningún tipo de actividad criminal o penal, ni use ni tenga contacto con drogas ilícitas.
Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
No puede tener, utilizar, poseer un arma de fuego o munición.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and follow receipt with the court.
Tiene que ir y entregar cualquier tipo de arma, munición o permiso de arma al departamento de policía, a la estación de policía más cercana, después de que salga del tribunal.
You may return to the victim's residence one time only within 48 hours of your release from jail.
Puede volver a la residencia de la víctima una vez únicamente en las próximas 48 horas después de que usted salga de la cárcel.
You must be accompanied by a police officer
Tiene que ser acompañado de un policía
so that you can retrieve your personal clothing, health items, medication, personal and business related paperwork, and work tools.
Usted tiene que estar acompañado de un policía para poder ir y recoger su ropa, sus cosas personales, sus documentos, cualquier herramienta de trabajo o que necesite para sus cosas personales.
If you go to the victim's home without the police or if you stay there, you will be arrested.
Si va a la casa de la víctima sin la policía o solo va a estar arrestado.
You understand the stay away order, sir?
¿Entiende la orden de alejamiento, señor?
I thank you. Your
Gracias.
bond is $5,000 and you do have an immigration hold. Good luck to
Su
you.
fianza son $5,000, pero tiene una retención de inmigración. Mucha suerte, señor.
Next case is Jerry Danz.
All right, let's take a time out from there for a minute. So I did screenshot Judge Belerjan's court. And why is this shouting at me? Stop shouting at me. There we go. I did screenshot Judge Belerjan's court, and if you look at the top right, behind him, that is the headless judge that will be replacing him in a day or two. I just thought it was hilarious. I love how Zoom works, or in that case, doesn't work. Let's go to Texas in our continued efforts per request to provide 9 to 11% more. Judge Boyd. Here's Judge Boyd.
All right, court is calling 2025 CR 000240 and 2025 CR 013090. State versus Elizabeth Settle. Can I have parties announced for the record?
Hunter Morris for the state. Will Brooks for the defendant, Judge.
All right, and you're Miss Settle? All right, we were here on July 28th. The court ordered you to have a drug testing done, and that was completed. Is that correct?
Yes, Your Honor.
And what were the results?
So she was positive, Your Honor, but it was for her medication assisted treatment. There was nothing else, no other substances.
All right. So the other reason why I had this case recalled back, because this is actually a tough case, right? And it's a tough case. And when you read it on the surface, you should be going to prison. But then there are other things for me to consider as well. The fact that you have a child and it appears that you have changed your life. And defense, I believe yesterday you said that she was being accepted into felony drug court.
Yes, Judge, and also I had some argument for the court too. The court was ready, but that is correct, Judge. She was screened for felony drug court. They did not accept her because at the time she had not been sentenced. But I verified with felony drug court that should she be placed on probation, they are able to accept her in and can squeeze her in next week.
All right, so state.
Yes, Judge.
I understand why the reason you're asking for prison time. I do, and I want you, Ms. Settle, to internalize what I'm saying. What I'm considering is the fact that she has a child. It appears that she has changed. Sometimes it takes people a long time to have a wake-up call. I still don't understand why you keep having children when your life is not where it should be. But usually when people are addicted to drugs, they're not thinking appropriately to begin with. They're not thinking about the future. They're not thinking about how their drug use will impact everyone else. And state on this case, I see that you're asking for a cap of 6 years in the prison. And one case is a second-degree felony. And the other case is a third-degree felony. And I'm assuming she has restitution to pay?
If it isn't included in that plea bargain right there, Judge, then no certain amount.
All right. So we're going to see the amount of restitution, and state you've had a chance to hear her testimony. Are you still going to be requesting prison time?
Judge, the position of the state is that this offer was made considering the history, the knowledge that Ms. Settle has been before this court previously, also with a new child, asking for the same type of leniency and treatment, and was offered that leniency and treatment and turned it down and returned directly to that life. And so it's not just Ms. Settle the state is concerned about, but it's Ms. Settle's children, it's Ms. Settle's family, and it's Ms. Settle's community many of which were victims of Miss Settle. And that is the reason the state is opposed, but the state is cognizant of what appears to be genuine changes in Miss Settle's life.
All right. And I know that this involves her mother.
Yes, Judge. So the world is an ironic place. It turns out I'm appointed to represent Miss Settle, but I have known Miss Settle since she was about knee high. I've known the complainant, her mother, and also her brother, who's referenced in the PSI, someone that I went to high school with, was close friends with. So I've known this family a long time. I've spoken to the complainant, to her mother, Judge. She is certainly at wit's end with Miss Settle. She's spent a great deal of money helping her out, trying to get her on her feet. But it is also clear in the PSI that she is seeing and she's witnessed some of the changes that Miss Settle has made in her life and has made. And the question came up yesterday, Judge, what's different or what's changed? And I think the distinction between this time and last time she did not do what she was supposed to do for you, Judge. It's very clear in the PSI back in 2020, she was going for things. She was released from the jail accidentally. She skipped out on GPS. There were all sorts of issues, Judge. In this instance, since both when she was arrested and then certainly after being released on bond, she's made great strides to try and do what she's supposed to do. She's been on GPS. She's been compliant. She's been enrolling in programs. She's tried to be a parent to her mother or to her child. She's also shown up here today, Judge. She's not run off. She's not fled. She's not skipping out on things. And when you're talking about therapeutic justice, Judge, when someone's an addict, there's no such thing as a cure. But it seems to me like she's trying to make some legitimate life changes. And I think society and Miss Settle would be served better by trying to get her some therapeutic justice and trying to continue her down this path rather than sending her to prison again. PSI, the complainants themselves don't indicate that they'd like Miss Settle to go to jail, prison. Her mother certainly would like Miss Settle to have the threat of prison or jail time hanging over her head, which is something I think is a great motivator a lot of times. So for those reasons, Judge, we're asking the court to consider probation or community supervision in some form in order into the drug court program.
All right, anything you wish to add, State?
Judge, the state stands by its concern about Miss Settle being a good probationer, a good candidate for probation. That being said, the emphasis from the complainants was that if this court were to grant supervision, the state would ask for a very structured supervision, because I do believe that it is a necessity in Miss Settle's life at this point. I believe drug court would be appropriate and, if needed, inpatient treatment.
All right. So the court is going to give you a choice. Some people say my probation is very difficult. I'm sure you're aware of that, as I've sentenced you before for not doing what you're supposed to do. I'm going to give you a choice. I can sentence you today, and I will sentence you to 3 years in the prison. Otherwise, the plea negotiation needs to be reworked. And by that, this is what I mean. The case that's a second-degree felony, I will give you deferred adjudication. And if you were revoked, you're looking at 20 years in the prison. Do you understand? Sure. And then on the case that's a third-degree felony, I would convict you, but I want the underlying to be 10 years. So you can discuss that with your attorney.
Judge, she'd like the opportunity for probation, Your Honor.
All right, so normally, legally and ethically, I'm not allowed to interfere with negotiations. But what I'm telling you and telling your client on the cap of 6 offer, for me to request that it be an underlying of a cap of 10, that's changing your plea negotiations. And if you want a jury trial on that, you can have a jury trial on that. Do you understand?
Yes, ma'am.
All right.
Judge, on the second degree case,
Mhm.
is there no application for deferred indicated in that plea bargain agreement?
On that one, let me see. No, it just says that you're all opposed to community supervision in deferred adjudication, but I do have an application for deferred adjudication on that case. And on the firearm case, there is again, there's, the state is opposed, but there is an application for deferred on that case.
Okay. So the only one we would need to change is the one with the conviction, so the third degree.
Yes.
This court could give them 10 years deferred on a cap of 6. Opposed.
Well, no, on the unlawful, we're off the record, on the unlawful possession of the court wants a conviction on that case.
Okay.
So there will be guilty, but I want her underlying to be the 10 years.
Understood.
And then on the other case at the second degree, I'll give her the deferred adjudication. So the reason why I'm doing that is because then on both cases, you would be subject to the full range of punishment if you were revoked. Do you understand?
Yes. Understood, Judge.
So if you all want to change that to a cap of 10 and state, I'll still note that you're opposed.
Yes, ma'am.
And Ms. Abrams, on Ms. Settles, defense counsel has told me that felony drug court will accept her. And counsel, is she currently on GPS?
Yes, she is, Judge.
All right, we're going to continue with the GPS. Yes.
The case ending in 240, are we proceeding on count 1 or just 2?
Let me see. They're proceeding.
Okay.
They're proceeding on count 2 as a repeater. I'm sorry, wait a minute. They're proceeding on count 1. They're waiving count 2 in the repeater.
Judge.
Yes.
Here's that docket back and we initialed the plea bargain change.
All right, thank you, Hunter. All right, we're back on the record. Is there anything else from either side before the court enters its orders?
Nothing from the state, Judge.
No, just that we have no objection to the change from the cap 6 to the cap 10 here.
All right. Then in cause number 2025 CR 000240, the court is going to grant your application for deferred adjudication. Court is going to sentence you to 10 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. This is to run concurrent with 2024 CR 013090. With regards to this, no harmful or injurious contact with KPEC and family. And then there's no contact with Linda Vargas, Destiny Thurston, Juan Uriega.
Uriega, Judge.
Yeah, thank you. I look at Deputy Laura because she's like, I'm trying to teach you. David Getz, Goetz, or Dick Creamer. And there'll be restitution, if any, to all complainants. If there's an issue with the restitution amount, we can have a restitution hearing. And Ms. Ferguson, can you set this in 45 days for restitution hearing, please? In case there is any.
Fair enough.
All right, what date? All right, we're gonna come back on September 11th and state this just to see if there's any restitution amount that's owed. And we'll have a restitution hearing on that day.
Yes, ma'am.
Just one moment. Deputy Laura, you okay? Thank you. All right, there's to be no contact with Rudy Rodriguez. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's complete, 100 hours will be deemed satisfied. There's $1,000 fine that will be probated. And there's to be a referral to felony drug court. If for some reason she's not accepted in a felony drug court, she's to come back to this court. However, counsel has informed me she has been accepted. And there's to be continued GPS until further notice. Probation, is there anything else with regards to that sentencing?
Yes. Are you waiting?
Yes.
And can you please, no contact, did you say no harmful or injurious?
No harmful or injurious contact with PECK, PECK, and family. And then there's to be no contact with Linda Vargas, Destiny Thurston, THURSTEN, Juan Uriega, David Getz, GOETZ, and Dick Creamer, and Rudy Rodriguez.
Judge, to put a fly in the ointment, Mr. Rodriguez is actually the child's father.
I'm just going by what's in the plea paperwork. So that's something that will need to be addressed with Judge Glenn. Probation, is there anything else? Anything else with regards to sentencing in that cause number, counsel?
Nothing from the state judge.
Nothing from defense, Your Honor.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. And that cause number, did you review it with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Next, we're moving to cause number 2024 CR 01309. All right, the court is going to sentence you, the court is going to find you guilty. The court is going to sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. 200 hours of community service restitution. The court will show that 100 hours is satisfied upon the completion of parenting classes. GPS, and I'm sorry, probation will do partial GPS for employment and treatment in each cause number. Waive GPS fees. This is run concurrent with 2025 CR 000240 and referral to felony drug court. And again, if felony drug court for some reason does not accept her, she's to come back to this court. Probation, is there anything else with regards to sentencing?
It's on the other call number as well, Phil visits.
Oh, thank you so much. Field visits 1 time per month until further notice.
And can you clarify which count on that call number?
The one I just read, the unlawful possession?
Yes, sir.
They are proceeding on count 1 and they're waiving count 2. Is there anything else with regards to sentencing in that cause number?
No, Judge.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You say you have a new child. Your counselors told me you have a newborn, that you have finally, the haze has been cleared and you're finally going to do what needs to be done. In each of these cases, in one case, you're looking at 20 years if you're revoked. In the other case, you're looking at 10 years if you're revoked. So from here on out, everything you do, you need to ask yourself 2 questions. Is this something that could potentially result in me being revoked? If the answer is yes, don't do it. If the answer is maybe, don't do it. If there's anything else that's in between, you need to contact your attorney. Do you understand? All right. And if you're not going to do it for yourself, you need to do it for your child. All right. Thank you, counsel. Thank you.
Thank you, Judge.
Thank you. It's always great seeing both of you guys.
You too, Judge.
All right. Thank you. So Hunter, how's it been going?
So I gotta say, the first thing that she needs to do is set a backup plan for her children, because we know through the stats that we've gone through a bunch of times on this channel, the odds of her making it that long are incredibly slim. I hope she does, but the stats prove it out. The odds are very much against her, so I hope they have plans in place for the kids. It's creeping up on lunchtime on the East Coast. Let's see how Glazer's holding up.
Yes.
All right, thank you.
Gracias.
So it happened a month ago. How long have you lived here in Miami?
Pasó hace un mes. ¿Hace cuánto viven en Miami?
Yo vivo hace casi 8 años.
I've lived here for about 8 years.
Okay. I'll set his bond at $3,000.
Fianza $3,000.
Okay. So he can bond out of jail. Thank you for coming in, ma'am.
Thank you.
Gracias.
Next case is Josue Chavez.
Spanish, please.
Thank you. Good morning, sir. So, Mr. Chavez, you were arrested for 1 count of conspiracy to commit kidnapping and battery. Madam Interpreter, we can't hear you.
Señor, usted fue arrestado por un cargo de... may I have repetition, Your Honor? Sorry.
Sure, a conspiracy to commit kidnapping and battery.
Conspiración para cometer, para quitar una persona y agresión.
Sir, can you afford to hire a private lawyer?
¿Usted puede pagar a un abogado privado, señor?
No, right now.
I will appoint the public defender's office for you.
Voy a asignar entonces a la oficina del abogado público para usted.
So I need a moment to review the arrest affidavit for probable cause.
Voy a revisar el arresto, el reporte de arresto para causa probable.
So Judge, it's definitely not a conspiracy. Is it a false imprisonment? Is it an attempt?
Definitely not a kidnapping. It looks like at best a false imprisonment. Looks like he left the room at some point. He was at the gate when the police arrived. Looks like she was free to leave.
Dice que probablemente no fue que la tuvieron bajo su voluntad falsamente, es que él la encerró y se fue y no le permitió irse.
I'm just reading this, it's not very well written. If anything, it would be a false imprisonment. It's not a kidnapping. Sir, you are ordered to stay away from the alleged victim, Kimberly Mendez.
Señor, usted se le ordena mantenerse alejado de la víctima Kimberly Méndez.
No contact with the alleged victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
Señor, usted no puede comunicarse con ella ni directa ni indirectamente a través de personas, por escrito, por teléfono o a través de terceras personas.
No contact with the victim through social media or other electronic means.
Ningún tipo de contacto con la víctima por redes sociales o otro tipo de maneras electrónicas.
And you must stay at least 500 feet away, stay at least 500 feet away from the victim, her home and school and place of employment at all times.
Tiene que mantenerse alejado siempre y en todo momento de la víctima, el lugar donde vive, de trabajo y donde se encuentra.
Do not engage in any criminal activity. Do not use or possess illegal drugs.
No se involucra en ningún tipo de actividad ilícita o penal y tampoco use ni posea drogas ilícitas.
And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
No use ni tenga en su posesión ni tenga con usted ningún tipo de arma, munición, arma de fuego o permiso.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court.
Tiene que entregar cualquier tipo de arma o munición o permiso para portar arma a la estación de policía más cercana apenas salga del tribunal.
You may return to the victim's residence one time only within 48 hours of your release from jail.
Puede volver a la lugar donde está la víctima una única vez en 48 horas después de que usted salga de la cárcel.
You must be accompanied by a police officer
Tiene que estar acompañado por un oficial de la policía
so that you can retrieve your personal clothing, health items, medication, personal and business related paperwork, and work tools.
para que usted pueda tomar si quiere sus ropas, cosas personales, herramientas de trabajo, documentos o cualquier otra cosa que necesite.
If you go to the victim's home without the police, or if you stay there, you will be arrested.
Si va a la casa de la víctima sin la policía o se queda ahí, va a ser arrestado.
Do you understand the stay away order, sir?
¿Entiende la orden de alejamiento, señor?
Yes, I do.
Okay, thank you. I'm setting a bond. Count 1, false imprisonment is $2,500. Count 2, battery is $1,000.
Estoy fija.
I'll
The
withdraw
state's-
based upon the court's finding.
Thank you. Have a nice day.
Que tenga buen día.
Next, Jesus Castano.
Okay, para su fianza está.
Your volume's
She's holding up better than expected. Good for her. Let's go to Wisconsin. Judge Mogan.
There you go.
All right. We will go on the record in the matter 24 CF 162, State of Wisconsin versus Jack Fenton. This state appears through District Attorney Kevin Schmidt in person. We have Charlene Perrin, Defense Counsel in person. Mr. Fenton appears by video conferencing in custody in Burnett County Jail. We're set today in this matter for a motion to admit child audio visual statements for this case. I have reviewed the motion. I have reviewed the response from the defense. I have also reviewed the confidential flash drive. And I have opened it and signed it and dated it as I am required. Ms. Perrin, in your response, you indicated that for the most part, you do not contest having the audio visual information from the child or children. However, there is a few caveats that you wish to discuss or to argue in front of the court, I believe. You have the floor.
Thank you, Your Honor.
Yes, I do think that the officer who did the interviews did a nice job of verifying that the children knew the difference between the truth and a lie. I think that's one important factor that the court has to consider. And so otherwise, upon review of the videos and review of the law, I don't have an objection. I do believe the younger child makes some statements about what other people said, other than the defendant. So I believe those things are hearsay that should be redacted. And I think Mr. Schmidt and I can discuss that and redact those before those are played at trial. And then I believe there's a provision that the prosecution can provide a transcript. Sometimes I've noted during trial that transcripts are provided to the jury as well. I'm not sure if Mr. Schmidt has determined whether he's going to do that or not, but I would like transcripts of the recordings as well. So I'm requesting that.
For the court scheduling order, it is a directive that if they are going to play a video, they must get a transcript of that video, not from my court reporter, but from another court reporter. My court reporter can do that, but depends on her availability. So it is in the scheduling order, not only for counsel, but for jury as well.
Okay.
All right, Mr. Schmidt with a response to Ms. Perrin's statements here.
So technically the scheduling order says upon motion, the court can order transcripts. I have no objection to preparing transcripts and providing them to counsel. I would object to giving them to the jury. There's a reason one of the preliminary instructions is transcripts not available to jury. And it cautions heavily against ever doing that with the jury, because if they rely on a transcript instead of their memory, they've already done appealable error. So if Ms. Perrin wants them available for us to use, to refer to be able to like cross-examine witnesses, I'm okay with doing that, paying for it and providing it. I don't know if I can provide it if I do it through a court reporter. I think they would have, there's rules to that. I'd have to look into it. I think they have to pay a smaller amount is what the court reporters usually say. But I'm fine with that, just not admitting it to the jury or sending it as evidence. To the hearsay thing, the purpose I want to use the younger child is to corroborate what the victim said to her. That's the sole purpose I'm using it. Since I'm going to be using it after the victim goes first, it's not hearsay, because one of the exclusions of hearsay is someone's statement about what someone else said after they've already testified and been subject to cross-examination, and it's to rebut an implied argument of lying or fabrication. That's in 908, I think is the hearsay statute. Let me double check that.
Yes, it is.
Yeah. So because I plan using it afterwards, anything EMA says about DAA, what she said to her, I think will not be hearsay. If there were other people's statements you're concerned about, I don't. If you articulate that to me, we could talk. But yeah.
So when I've been in other trials and there's been transcripts prepared, because sometimes it's difficult to hear everything that specifically children say during their testimony, during a video. Sometimes a jury is provided a transcript while the video is playing.
That's exactly my experience, and I've done it half a dozen times in trials.
Not to take back. So thank you. So the other thing is, yes, I was speaking partially to statements other people, the child said about what other people said other than the other alleged victim. But I also think the argument counsel is making is premature and would depend on how evidence comes in and what arguments are made.
I mean, DAA is going to play a video and testify that the defendant sexually assaulted her. The defendant can't not say that's false. Like, that wouldn't be a defense.
Well, you're talking about the victim. I think Ms. Perrin is speaking of the sister of the victim.
Right. So
right.
I guess I don't understand what her argument is.
Her argument is, it all depends on how the trial flows.
I mean, if I do DA first and EMA next, then it's just not hearsay is what I'm saying. Because DA has already testified and been subject to cross-examination.
And I think that's the understanding, but just in case it doesn't, is Ms. Perrin's argument.
Well, yes, and if I understand counsel's argument, counsel is saying that it's corroboration of what the alleged victim, the younger child is saying that her sister said the same thing to her. And so it's corroboration of what she said. And so if the defense claims that she's lying or something like that, that it's a consistent statement. And so I think part of whether that comes in or not depends on what the cross is of the alleged victim and how her testimony comes in.
Right. I'm understanding her flow. Are you?
I'm understanding what she's saying, but I don't think it makes any sense. Because like I said, the defense isn't going to argue that what DA said is true, that Mr. Fenton sexually assaulted her, which is why 90801 sub 4 sub a sub 2 offered to rebut an express or implied charge against the declarant of fabrication or influence or motive. That's what it's for. I think it's unreasonable to say if the defense doesn't ask a question or doesn't accuse the person of lying in the cross, that I can't offer a statement for that purpose. I think that's going a bit too far. Because no good attorney would just accuse a witness of lying on the stand. That's not how impeachment works.
I'm just not going to respond to that. Yeah.
Well, the hearsay information is noted. I'm pulling up the statute right now. You said sub 1, sub 2? No.
Sub 4 in 90801, and then sub a sub 2. That is how statements corroborating other witnesses are introduced in trials, through that sub. The one above it is how you introduce witnesses to impeach others.
90801 sub 4 A2 states consistent that the declarant testifies at the trial or hearing and is subject to cross-examination concerning the statement, and the statement is consistent with the declarant's testimony and is offered to rebut an express or implied charge against the declarant of recent fabrication or improper influence or motive.
Yeah, so obviously the rules of evidence were not intended to prevent witnesses corroborating other witnesses by saying, hey, they said the same thing to me. That would be an unreasonable view of the hearsay statute.
Well, that is accurate and true. You can't corroborate. So are you asking me to make a ruling right now, or are you asking that this be open to objections determining on how the examination of, I'm just going to say the sister goes, this parent?
That is, I mean, my understanding is that today is about whether the video would get in, and then the ruling on whether, so, you know, we have no objection to that. So whether the video gets in as hearsay is a question that the court would determine depending on how things go at trial. That's my position. Because I don't think the court can make that decision until after the alleged victim testifies. I just don't think it's possible. That's my opinion.
All right, so based upon the stipulation of the parties, the video will be admitted, and the court will wait until the trial to determine if there is an objection. And then the court will rule based upon what has occurred and then the objection made at the time, if any.
So just to clarify then, the only hearsay statement you were alluding to in your letter was EMA saying what DAA told her.
Right. I don't object to the other one at all. The older, the alleged victims.
I just wanted to make
video.
sure, because obviously there's some like mom said this, dad said this, not really relevant to the case at all. You know what I mean?
Well, I don't know if I believe that's not relevant, but that's what I was speaking
I'm trying to
to.
clarify what you're objecting to.
All right, I'm just hearing, what I'm hearing right now, though, is that they're being admitted, and Ms. Perrin will be doing her job at the trial, and if she hears anything she doesn't believe should be admissible and should be in the jury's review and under their consideration during the trial, she will object, and the court will determine at that time whether or not the objection is sustained or overruled.
Yes.
All right. So that could be with any statement made by the parents. It could be any statement made by the sister. Again, I've reviewed the two interviews, and I believe there were statements of the parents. I can't recall off the top of my head exactly what they were stating, when and why and how. So that's where we are with that, with the video. It is admitted with parameters of the rules of evidence during the trial. All right, what else do we need to discuss today?
I don't think there's anything else to discuss.
I think we can just briefly, I saw that Ms. Perrin wrote a letter because she knows that we're waiting for DNA results on an article of clothing of the victim. I only saw that letter this morning. I tried calling the lab. The analyst wasn't in, so I'll just keep everybody updated on that.
Okay.
And hopefully it won't be a problem, but I just wanted to just let the court know in case that it becomes a problem.
All right, so noted. And we do have the letter. I do have the information out from the DA as it relates to that DNA issue. And if we have to have a hearing prior to final pretrial to discuss it, we will, or we'll discuss it at final pretrial.
Actually, I have one more update. After I called, the crime lab called back and my secretary answered. They've done testing and they're in the process of writing the report. So we should have it soon. I don't know what the results of the report are yet based off of that note.
That's great.
All right, so then we should have information definitely prior to the final pretrial, which is set to occur on August 28th.
Then that should give me time to do what I need to do.
All right. Anything further that we need to address today?
Not from me.
No, thank you.
Okay, well then, thank you. We have our we have another status on August 12th, 2:15. I guess we can address any of the issues we have then, and then we have the final pretrial, August 28th. All right, if there's nothing further, we are adjourned.
Okay, she's adjourned and we're going to move on. Let's go to Michigan and we will spend some time with Judge Corey Wiggins. He currently has a video on this channel that's trending, so let's spend some time with him.
I can see you're trying to unmute, but for some reason it's not working. I just want to let you know that I have signed the bind over on your case and you've been bound over to circuit court. So I'm not exactly sure why you're here today. You were set for 2 o'clock this afternoon, but that matter has been taken care of. So you are free to leave. All right, court next calls the case of the people of the state of Michigan versus Brandon Eaton. This is case number 253092FY. Appearances starting with the prosecutor.
Joanna Carey for the people.
Good morning, Your Honor. Allison Cassis on behalf of Mr. Eaton.
And Mr. Eaton, you're appearing by Zoom as well. Are you able to see and hear the court?
Yes, Your Honor.
All right. We are here for a probable cause conference. It looks like there is a potential resolution. Is that accurate, Ms. Carey?
Yes, I believe so.
And then it looks like that, from what I'm seeing, that if he pays restitution in full before the plea, then the plea would be larceny less than 200 or financial transaction device without consent. Is that accurate?
Correct.
All right. And we are still set for a prelim then next week. Is there any discovery issues or anything like that we need to be concerned with as far as you know?
No, Your Honor.
It's my understanding that you do plan on entering a plea, but we would like it to be set. We can either do that at the time of the prelim or set it separately for a plea and sentence, but I think we just wanted a little more time so he could get that together.
It looks like the restitution is $187. Will next week be enough time to get that $187 together, or do you want some more time for that?
Your Honor, if I could be given
Mr. Eaton, I'm sorry, I'm speaking to your attorney.
Oh, I apologize.
1 week would be sufficient, but if you're able to push it out to the 2-week mark, that would be even easier for him to make the payment.
Ms. Carey, do you have any objection to going out 2 weeks?
I do not.
All right, then we will go ahead and we will set this out for 2 weeks. Sounds like we have a stipulation to waive the 21 days then.
Yes.
And we will set out prelim for 2 weeks. Anything else on this matter before we adjourn?
There's not. Can you please confirm what time on the next date?
It would be 10 o'clock.
10 o'clock. Thank you.
No.
Oh, I'm sorry. It'd be a prelim, 2 o'clock. I'm sorry. I apologize for that.
The 12th.
I'm sorry.
We'd be on the 12th.
Which would be the August 12th.
Okay. Thank you.
All right. We're adjourned on that matter.
He's in jail.
Well, he's between people. Let's go back to Judge Boyd.
All right. Mr. Lopez, today is your plea deadline date?
Yes, Your Honor. I'm covering for Ms. Knowles this morning. When I covered Mr. Jarahan, there's still some discovery outstanding. And they're asking the court to reset the plea deadline one time to allow the state to provide us that discovery.
Okay, what discovery is missing?
Judge, it is actually missing. I looked on Veripic and they don't have the body cams on there, and that's what's missing.
Okay.
And I was unaware, the offer had been extended. I just was unaware until presently that I believe Caitlin Knowles was the main attorney on this. And I was just notified today that she had notified Mr. Solansky that.
All right, so when do you believe you'll have that?
2 weeks to 4 weeks, Judge. I mean, Megan Galloway has just emailed BCSO to obtain that.
All right, Ms. Ferguson. If you'll extend this plea deadline date for 30 days, there'll be no further extensions.
Thank you, Your Honor.
All right, thank you. What date? All right, August 21st. Thank you for addressing appropriately for court. Once you sign the reset form, you're excused, okay? Thank you. Thank you.
Excuse.
Yes.
All right, let's go back to Fulton County and Judge Morrow.
And is Miss McLeod going to be on the line with us? Are these her cases for the conflict today?
She's here.
She's on the line. Oh, there you go. Ms. McLeod.
Good morning.
Okay, good morning. I'm sorry I didn't see you there. I just wanted to make sure.
I'm here.
All right, so courtroom 2, we'll get in touch with Attorney Render, and also Ms. McLeod is with us. So if you want to do her cases as well, thank you.
We can go to position 4142, Mr. Pierre.
Which one? And what are we doing with Mr. Pierre, Ms. McLeod?
Your Honor, this is going to be a non-negotiated plea.
Okay. Good morning, Mr. Pierre. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Will you raise your right hand for me, please, sir? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, very good. Thank you, sir. You can place your hand down. Good morning, Ms. Washington. Are you with me?
Good morning, Your Honor.
Yes. Do you have Mr. Pierre's history for me, please?
Yes. There are 9 arrest cycles out of Florida, including an aggravated assault with a deadly weapon, criminal mischief in 2017, a 2007 misdemeanor conviction for possession of marijuana. There was also a 2005 homicide offense that was negligent.
And that was a conviction, correct, Ms. Washington?
That was a conviction, yes. There are 10 arrest cycles out of Georgia, an FTA from 2025. There was a simple assault arrest in 2024. No disposition listed. There was also a battery arrest in 2024. No disposition was listed. An FTA in 2023. Also, well, 2 FTAs in 2023, and nothing further, Your Honor.
Yes, Mr. Sirocco. Will you give me the facts as well, please?
I will, Judge. For the first case, it's position 41, the battery. This was from February 24th of last year, happened at 20 Wall Street Southeast, Atlanta. This was around 1 a.m. This was a passerby citizen that had flagged down an officer and pointed toward a man on the sidewalk who was holding his face, screaming in pain. Officer made contact with that person, the victim, Mr. Jeffrey Biggers. He explained that another individual had sprayed his face with mace during a dispute where the defendant came up to him and his friend, requesting money from the friend. The victim told the defendant to leave him alone, go away. And that's when they got into a verbal disagreement, and at which point the defendant then sprayed him in the face with mace. That description was provided. There was a witness of that incident, and the defendant was ultimately located based on the description where they had said he'd gone. Officer reviewed video footage of the street camera at the intersection, which showed the defendant approaching the victim and his friend, who was then seen in a verbal dispute. Video showed that the victim, with his hands at his side, never attempted to attack the defendant, and then the defendant was seen spraying him in the face and running away. He sustained swollen eyes and redness from the incident that the officer observed. And so that's the first incident here. And the second, which is the simple battery from May of last year, on May 20th of last year, to be specific, this was at 50 Upper Alabama Street, the Express Pharmacy there. Law enforcement responded to a simple assault call, and upon arrival, the officer stated the defendant was detained on scene for attacking a Mr. Derek Morris, the victim in this case, in front of the pharmacy. Made contact with Mr. Morris. He explained the defendant walked up on him and just started striking him with his fist while he's sitting outside the store minding his business. Was struck multiple times with his fist, and then proceeded to take off the victim's shoe and beat him with that. The defendant admitted that he choked Mr. Morris by the neck. The video footage was captured and uploaded showing the defendant as the aggressor in the altercation. So this is two violent incidents here. You've heard about his history, which consists of violence, including that manslaughter conviction from 2005, but more recently that aggravated assault with a deadly weapon conviction from 2017 out of Florida. He most recently has convictions for theft by taking from last year, criminal damage to property in the second degree from this year. So given the history of violence here, and his recent convictions, the state's recommendation for the battery is a time served, 240 days, credit for time served, 240 days. There's several intervals of time he's served for this charge, so I won't go into each of them, but 240 days credit. On 24 CR 0031666H, the simple battery, 12 months probation consecutive with the position is 41, the battery case, 12 weeks anger management. This would be probated sentence with 12 weeks anger management, BHET or MHET prior to release. No further contact with Mr. Jeffrey Biggers and Derek Morris. Stay away from 20 Wall Street, Southeast Atlanta, and the Express Pharmacy at 50 Upper Alabama Street in Atlanta. No weapons. That is all for the state. We would sound for Mr. Biggers and Mr. Morris at this time if they are on the line and wish to speak.
If either of those people are on the line and wish to address the court, now is your opportunity. Doesn't appear so. Ms. McLeod?
Yes, Your Honor, good morning.
Good morning.
I am asking that the court consider allowing my client to get out on time served, and here's why. Mr. Pierre was accepted into the mental health court, and he has been in good standing with that court for some time. He was in placement for a while and was doing quite well in the placement situation, but that ended. Then there was an attempt made to place him somewhere else. And he had been placed in another facility which was totally incompatible because some disclosures were not made that this was kind of a religious institution where people had to go and pray 3 or 4 times a day, and it was not a suitable environment for him. So he also had to leave that particular environment. Up until 2 weeks ago, the administration of the court was trying to find him another placement. Throughout all of this, he's been always in good standing with the court. He's been very cooperative. He had been doing very, very well in the program. And the only reason why he's not been able to continue with the program is that placement could not be found for him, Your Honor. He has spent a lot of time in jail. I noticed that pretrial mentioned about an FTA. This was out of the city of Chambly. I was able to contact them, and they were quite willing to lift that FTA when I explained to them what was happening with my client. And I really believe, Your Honor, that given how long he stayed in jail, given how cooperative he was with the mental health program, and this is on the record with the court, that he was very, very cooperative. And when he was placed into that facility, I think it was for 2 months, he did very well there. It's just that it ran out. What I don't like about the state's plea offer, Your Honor, is that they want him to do a BHET or MHET and to do that prior to his release. We do not know how long that is going to take. They also want to have him on probation. I believe that he's done sufficient time to satisfy these charges, Your Honor. And I do not think he's going to necessarily do well on probation because he has some challenges with housing and some other stuff. He does have a mentor out there who has contacted me from time to time because there was some issue with drug use at some point, Your Honor. But he's been pretty much on the straight and narrow. As I say, he has a mentor out there who's interested in him, and he really wants to turn his life around. He's been behind bars, and he's been a model inmate. There's been no issues at all with him in the jail. And as I said, there were no issues with him in mental health court. So this is why I'm asking that it just be straight time served at this point, Your Honor.
So he's participating.
With respect, go ahead.
Go ahead.
Sorry to interrupt, Judge. Go ahead.
No, I just want to get more clarification on the mental health court. He's currently actively enrolled and participating in mental health court?
Yes, Your Honor. He was up until 2 weeks ago, but then because they could not find placement for him, they were trying to find a placement for him. Then Judge Richardson just said, well, he's really been in jail a long time. And I honestly thought, I raised this last week, that it was determined at that time that it was going to be time served. But there's been no issues at all with him during the course of the time he's been in mental health court. We have had numerous sessions since he's been in there, since last year, Your Honor. And there are no issues at all. He's been in jail, there's been no issues. When he was transferred to that rehab facility, there was no issues there.
So we have that he was terminated. They were unable to find housing for him because wherever they had been trying, all the places that he was trying to get housing for, he had either been kicked out of already or was otherwise unqualified for. He was listed as too high need for the program. So there wasn't anything more they could do for him. And, with respect to MHET or BHET prior to release, with the issues with housing that we're seeing, that's why we want this done prior to his release. And
I know, but he's just sitting there, and he's been more than compliant. I can tell you that. It's not like he's in jail giving a lot of problems. It's not like he's gone to any kind of facilities and given anybody any problems. He has been compliant wherever he went. I know that the first time he went into rehab, he completed the entire program without any issues. That is a fact.
So what is the plan for him once he's released? Is there a plan, Ms. McLeod?
No, Your Honor, he needs housing. You know, he needs housing. That much I know. Go ahead, Mr. Pierre. He can speak, Your Honor. I don't mind if he says something.
Yes, Shauna, I do have plans to get in the shelter. The program I was in last time to I forgot the name, but I know how to go to 10 Park Place through my mental health, and I'm gonna get back to school.
Okay, I guess what I'm concerned about, Ms. McLeod, is that he has a place to go once he is released. He has someone that can monitor him, especially given these two charges.
But moreover than that, Judge, I mean, it's two violent incidences that were like from everything we've seen unprompted. We would be asking for anger management as well. We think that's more than appropriate given the facts here and his history. That conviction.
I understand what you're saying, Mr. Sirocco, but if he doesn't have a place to live, he doesn't have an income, how is he gonna pay for anger management? We're gonna set him up to be right back here. Again, I'm trying to come up with a solution that we don't have to have him come back to us. I understand the charges, I understand, but I also understand that he has some problems. And I'm trying to prevent him from coming back here. If we could get some kind of solution that would assist the court so that he has a place to go, Ms. McLeod, or he's working with someone. It does concern me though, although he has been in mental health court, that he did not complete it successfully and that he's just right back where he is.
Yes, he didn't complete it successfully, Your Honor, because there was an issue with placement. It's not because he did anything wrong in any particular situation.
Well, if there's an issue with placement, then there's an issue with having him placed.
I understand, Your Honor. I think because he had certain things in his background previously, with some of the places that we attempted to place him at, he could not be placed there because he did have granted that old situation from 2005, which is 20 years ago, and then something else in 2017. But what I'm saying is that whenever he's had to interact in a situation, like when he went out for that 6-week period to rehab, he did successfully complete that rehab and there were no issues there. Then they were trying to place him in something that was more long-term, but that did not happen. As I said, there was one situation where it was kind of a religious situation and was almost like being in a convent, and it just wasn't working for him because it required sort of prayer and fasting, and it was just not a good situation for him.
Okay, well, I need to find some kind of solution that is going to be a good situation for him. Because if I allow him just to go back on the street without any type of housing, without any type of support, without any type of help, then I can guarantee that he's going to be back here.
Yes.
And I'm trying to not do that for the sake of the public and for his own sake.
I understand, Your Honor.
If you all could help me with some type of solution that would assist him, maybe a social worker can visit with him and chime in and give me some type of, if we could get him some type of placement before I release him.
I think that would be helpful, Your Honor, but I think he also wants to say something, but I think he does need assistance, certainly with housing, if nothing else. What would you like to say, Mr. Pierre?
That's what I was saying, Your Honor. I'm going back to live with my sister in Riverdale. And I'm getting to school and all.
Okay, well, Ms. McLeod, if you want to speak with his sister in Riverdale, and if she is willing to accept him to come back to her home, then that would be something. You understand what I'm saying?
Yes, Your Honor. I need to speak to Mr. Pierre again because I'd be happy to speak with her.
So again, if there's some type of place, so let's have a social worker visit. I'm not going to take this plea today. why don't we have a social worker visit with her and assist you, Ms. McLeod, with some type of placement and come back with a plan for Mr. Pierre so that we can properly move him moving forward. Can we do that?
Would be fine, Your Honor. I would like the jail to call me so I can speak to him because I need to get a good number for his sister.
Okay, and if you don't have the, and I know that, that you all don't have access to the social worker sometimes with Mr. White, if we could get Ms. McLeod some assistance with the social worker, I'd appreciate it.
No worries, Judge.
Okay, thank you. So let's
Thank you, Your Honor.
let's put this on the calendar for next week to see if we can come up with some type of acceptable plan for everyone. And Mr. Sirocco, I'm happy for you and your office to be a part of this also, as far as, you know, so that we don't have him, you know, just recycle back, okay?
Sure.
Thank you,
Your Honor.
Appreciate it. We'll see you next week, Mr. Pierre.
Well, it's gonna be
All right, we haven't quite hit our 9 to 11% more Judge Boyd quota yet, so let's go back there. And this is a defendant that looks familiar to me. Let me know if he looks familiar to you.
Mr. Allen,
Hello.
not here yet.
just give me one moment. All right, if everyone can please whisper, we're going to go on the record. Court is calling 2025 CR 007563, State versus Ronald Allen. Could I have parties announced for the record, please?
Duffy Pitlock for the state of Texas, Your Honor.
Charles Butcher for the case.
All right, and are you Mr. Allen?
Yes, I am.
We were here yesterday. The court heard evidence on defense's motions. The court ordered or requested that both parties be present today to make their arguments. And so defense, it is your motion. So, and both parties agreed for the hearing that they would combine the motion to suppress and the motion to dismiss. The court requested if both parties would agree to combine the motion to dismiss and the motion to suppress due to objections that both parties were having to particular evidence. And some of the objections with regards to the motion to suppress were not appropriate for a motion to suppress, but they were appropriate in the motion to dismiss. So that is why both parties agreed to combine the two motions. So with regards to the motion to suppress, what I would like to start with is we'll start with number 2, where the defense's argument is there's no probable cause. You may address that, counsel.
Judge, regarding we did hear testimony from Mr. Allen, Officer Che, and Attorney Ireland. We heard Attorney Ireland's recording. We'd seen the state's theory take its full shape. The reason we think that this lacks there's a lack of criminal conduct on this matter, because from the outset, the prosecution relied on a paraphrase quote allegedly said by Mr. Allen, which was, "If I don't get custody, I will make history and there will be dead bodies everywhere." But when we heard the recording, that phrase was never heard by the court in the recording submitted by Mr. Ireland and played for the court. The actual statement made by Ronald was, quote, "So if I was going to do that and I knew all this stuff was going to happen, period, I'm prepared for Wednesday. But something is going to happen that's going to change history, whether you bust these guys or there's dead bodies everywhere, bro." Later, he says, because if they don't get busted, there's going to be dead bodies everywhere. Now, our contention is that neither of these statements includes an assertion of personal action on the part of Mr. Allen. There is no named victim. There is no identified target. And there is no expressed intent to carry out any kind of violence. It's also troubling that the DA's office or Detective Che did not fully review the audio, but simply adopted Mr. Ireland's paraphrase as fact. I think that this misstep undermines the reliability of the charging process and bolsters the necessity for judicial correction through either suppression or the dismissal.
All right, and with regards to no complainant being identified, is there really a need for a complainant to be identified if there's a threat? And I'm not saying it's a threat. These are just questions that I have, Mr. Allen. Is there a need to identify a singular person if there's an alleged threat that there will be bodies?
Well, I think a part of this is the nature of the charge is that this is a terroristic threat on a public servant. Although other public servants are discussed in the 12-minute recording that we heard, none of those public servants are specifically targeted in any of the statements that Mr. Allen made. They're talking generally about a number of things related to the legal strategy, related to the tactics that are being used. And basically, my client is speaking freely to his own lawyer.
All right, but I'm reading the indictment. Is there any objection to the court reviewing the indictment?
None from the state, Your Honor.
None here.
All right, so I'm reading the indictment, and the indictment reads that on or about April 21st, your client did threaten to commit an offense involving violence to a person, namely, and then it says to kill people with intent to place the public or a substantial group of the public in fear of serious bodily injury. So according to the indictment, it's saying a group of people and not necessarily a person who's a public servant.
Of course, Judge. We do recognize that that's what the indictment says. We accept that that's the indictment generally, but we do have issue with the idea that this statement has been taken out of context. He's not particularly naming that he's going to do anything to the court or to the courthouse or to any of the people that work here. I'm also, I think you should know, I've been practicing 15 years and I work in this courthouse every day. And I don't feel like Mr. Allen is a threat to this court either. Further, when we talk about this, Mr. Allen's testimony reflects a constitutional innocence to him because he testified that he believed he was speaking confidentially with his own lawyer. He had no intent to harm anyone. He was not emotionally stable at that point because of the difficulty that he was having with his custody matter. So he was also shocked to learn that the words that he mentioned in his own lawyer, where he has an expectation of privacy, were being recorded and being used against him to third parties.
All right, so do both parties stipulate that a client's conversation with his attorney in a legal capacity is confidential, that that's the bar? Do both parties stipulate to that?
The state understands that confidentiality bar is there with exceptions.
Yes. All right, so do both parties stipulate?
The state stipulates.
All right, so then the next question I have of both parties, is there an exception? And I think both parties know the answer to the confidentiality if there is a threat of violence or if there is a threat of a future crime.
Yes, the state is aware.
All right, and defense, do you stipulate to that?
Yes, Judge, we do know that there are rules, Rule 105C7 of the ethics rule provide for permissive disclosure to prevent criminal acts. And we anticipate that Ireland would be arguing that he had discretion under this section if he reasonably believed the disclosure was necessary to prevent a future crime. However, according to those rules, the comments inside of those rules, comment 13 to 14 in the rules that are promulgated by the state, the magnitude, proximity, and likelihood of harm must be weighed. The threat must appear imminent and grave, and the disclosure must be no greater than necessary. The problem here is that Ireland disclosed everything and voluntarily handed over a recording, and that recording was not narrowly tailored as a warning. And then we have his own testimony where Mr. Ireland gets on the stand and he tells us, also in the recording, "I'm not afraid of anything regarding this case." That contradicts a reasonable belief of a grave and imminent harm.
But counsel, wasn't his saying he's not afraid of anything about the case in reference to the pending civil case, not the alleged actions that we're here for today? I thought that's what he testified to.
Well, and I do know that, what we're really talking about is that the lawyer that testified, that was this man's lawyer, he continues to try to expand and express that he's in deeper fear than he was in the moment. And I think that's a vital distinction, because if there's a terroristic threat, I think that his action should be immediate. But rather, what Mr. Ireland did, he didn't immediately call 911. He immediately called the amicus attorney. He thinks he doesn't remember that, but we believe that he called the amicus attorney because we got a bill for that. And then further, he calls the Texas Bar Hotline, which is going to favor him making this disclosure, at least to mitigate the immediate harm. But I think on retrospect, after 100 days in jail, the harm and the potential harm has been mitigated.
All right, so let's start here. The first thing is that the court finds through stipulation, and I think both parties know, that when someone is speaking to their attorney about legal matters that they've been contracted to do, that normally it's privileged. But I think both parties have also stipulated that there are exceptions to that privilege. And one of them is if there is a threat of future criminal activity, or if there's a threat of harm to anyone else. So let's start. State, do you want to address whether or not the communication that was testified, that is the basis for this alleged offense, whether or not that was privileged?
Yes, Your Honor, that was not privileged communication. It is detailed in the exception for furtherance of criminal activity, express or implied intent by saying if X does not happen, then Y is going to happen. If X, I don't get my custody, then Y, there's going to be dead bodies everywhere. That is both express and implied. Express, dead bodies, implied, maybe the how. But this was not privileged communications between an attorney and a client. And no, the shift of the communication that you heard, the audio recording, that statement comes at like minute 10:45. I'm prepared for Wednesday, but something is going to happen that is going to change history. You bust these guys or there's dead bodies everywhere, bro. So to say that the attorney, Mr. Ireland, wasn't scared, that was at minute 4. And Your Honor was correct in assessing that that was not related to the future threat that was going to come 10 minutes later, 6 minutes later. That is not privileged communication. Those privileges are to ensure fair trial, trust between parties. The privilege is not intended to grant people a right to threaten and to use words to cause a reaction like what happened in this case. It's not privileged.
All right, so the court is going to find that there has not been a violation of the attorney-client privilege under the Disciplinary Code 1.05C7. The court is finding that the recording is not illegal, as Texas is a one-party consent state, and the attorney knew that he was recording and he was a part of the communication. There was no third party in the room. It was Mr. Allen and his attorney. Now, with regards to the warrant requirement, both parties stipulated that this was that the defendant was arrested under warrant. So there's a warrant requirement that has been met with regards to that. Now, the next thing I want to talk to you all about is whether or not the communication to his attorney that we're here for, whether or not that's protected speech. And that's a part of your motion as well, client, Mr. Butcher.
Yes, Judge, that goes towards the motion to dismiss regarding this. I think there's some particulars in the recording and in what was discussed with Mr. Ireland on the stand. There are a number of statements that Mr. Ireland stated that tend to show that at the moment, Michael Ireland was not afraid. His own words and conduct tend to prove it. First off, Mr. Ireland said, you can fire me if you want. If you think I'm not doing my job, then go ahead. I think the implication from that is that Mr. Ireland had a calm and professional demeanor and he was not in fear. Further, Mr. Ireland said, you're getting F. In that regard, he's aligning himself with the client emotionally and tactically. And I think that matters because he's continuing to engage in this as not somebody that's looking for a criminal intent, but he's looking for a way to align himself with his client and think about the custody case strategically and tactically. He even says, I agree with you when Mr. Allen indicates that he is concerned and afraid because of some coincidences that were happening in that litigation. Further, they even talk about subpoenaing a gentleman named Sherwood. So Mr. Ireland is strategically engaging regarding the subpoenas that he's going to issue and the work that he's going to do in furtherance of that custody case. Now, I realize that this court isn't about reviewing a custody case in any way, but what we think is that Ronald Allen's testimony reflects constitutional innocence because Mr. Allen testified that he believed he was speaking confidentially with his lawyer. He had no intent to harm anyone. He was emotionally distraught, particularly due to the custody losses, and he was shocked to learn that his words had been recorded. When we get further into this, Ronald also expresses his own fear in the recording because he says, I'm scared for my life, dude. That's not the speech of a would-be assailant. It's the language of a man trying to make sense of what he perceives as an unjust legal system. In my motion, I mentioned a number of cases that are constitutional cases, and one of them is the Watts case. In the Watts case, in a 1966 anti-draft rally in Washington, D.C., an 18-year-old draft dodger made the following remark, quote, if they ever make me carry a rifle, the first man I want to get in my sights is Lyndon Baines Johnson, LBJ. This, by the Supreme Court, was interpreted as a threat. This was interpreted as a threat by the authorities under the United States Code regarding terrorist threats toward the president. But the Supreme Court found in 1966 that they reversed a conviction holding that Watts' statement was political rhetoric and not a true threat, and therefore was protected speech under the First Amendment. Now, this applies because the context matters. True threats are not protected speech, but the government must prove that the speaker intended the statement to be understood as a serious expression of intent to inflict harm. So hyperbole, exaggeration, or emotional venting, even if it's crude or alarming, doesn't qualify as a true threat. Lower courts later differed on the objective versus subjective standard on this, but Watts did emphasize the importance of both context and intent. In reference to Ronald's case, this also was a vague and conditional statement. It was delivered in a nonviolent setting, and it was interpreted literally by the government, despite clear indications that it was a figurative rhetoric that Mr. Allen was engaged in. Similarly, this case, in Ronald's case, it was emotionally charged, but it was conditional, and it was made during a private dispute involving custody. Now, Texas courts regularly apply the Watts principles. There's another case called Lopez v. State, where 631 Southwest 3D 107. In that case, the court explicitly cites the Watts case in evaluating whether a defendant's statements were true threats or protected speech. And in that case, it was held that the defendant's statements about bombing a school were not protected speech because they were specifically targeted and intended to be taken seriously. But the key takeaway on that is that Texas courts always adopt the contextual approach from Watts, looking at the surrounding circumstances, the intent, and the audience. In this case, those factors are highly in favor of a dismissal for my client. Further, there's another case called State v. Hansen, where the courts recognize that political hyperbole, even if it's violent in tone, may be protected under Watts. There's also the Dorset v. State case where a defendant told officers, y'all better wear your vest because I'm going to start shooting. This was held as a true threat, but only because of the content, including a history of violence and the ongoing criminal conduct resulting in the officers responding in that case. Watts influences Texas law even without being codified. Texas courts do adopt some options of Watts because they talk about a true threat test as a conditional limitation in applying the Criminal Code 22.07. The judges are to act as gatekeepers even if the conduct appears to violate the literal text of the statute, but it must pass the Watts standard in these matters. There's another case, more recent in 2015, the Alanis v. United States case, where Judge the Supreme Court held that punishing threats require proof of a mens rea or a subjective intent to threaten. The person cannot be convicted. The Alanis case holds that a person cannot be convicted based on how others might perceive their words. Rather, the speaker must actually intend for those words to instill fear or communicate a threat. In this case, the full transcript demonstrates Ronald's alleged threat was embedded in an extended stream of anxious, erratic speculation and emotionally charged grievances, where at one point Ronald even says, I got called into jury duty the same week in the same courtroom. The odds of that is like me winning the lottery 20 times in a row. Bro, it didn't even happen. He further elaborates, hey, I had jury duty, dude. They asked me certain questions and they made me sit there all day. The same effing judge. They wanted to know what I knew and if I recognized those other two girls. When I read these statements, they don't seem to be statements of intent. They're statements of subjective fear, suspicion, and confusion. And it's exactly the kind of talk one might share only with their lawyer while trying to process whether the system is fair or rigged. So here, far from planning any violence, Ronald was exploring whether something conspiratorial was happening to him, and he was seeking his lawyer's validation and advice. In the same way in Alanis, the court emphasized that convictions under federal threat statutes require subjective intent. So the speaker must actually have intended the words to be understood as threatening. In that case, the court reversed a conviction that was based on an objective, reasonable person standard and holding that omitting a reference to intent in a criminal statute does not mean that the mere negligence is the appropriate mental state. So here, we might agree that the words that Ronald used in his lawyer's office were negligent because they might be interpreted as a threat, but his intention, and the state hasn't shown that his intention was to make a threat to the general public.
At this juncture, isn't whatever your client's intent, that's something for a jury to decide? Or if this were a bench trial, then it would be for me to decide. But is that correct? That's something for the jury to decide what his intentions were. At this point, based upon your motions, what you're here for is whether or not there was a warrant issued. It's been submitted that there was a warrant issued. Both parties stipulated to that. Whether or not the communication with his attorney was privileged or not. I'm finding that the communication was not privileged because it falls under the exception of a threat that was being made. So the threat that was being made, that wasn't privileged communication. It falls underneath the exception. Now, whether or not Mr. Allen, whether or not you meant that, or whether or not it was intentionally, knowingly, or whatever the mens rea may be, that's something for a jury to make that determination. At this point, this court, I'm just making rulings upon motions that are presented to me. But there are some things that I legally am not allowed to make rulings on. One of them is determining what your mens rea is, whether it was intentionally, knowingly, recklessly, whatever it may be. And that would be what is actually in the indictment. So in the indictment, In the indictment, they're stating that you made a threat with the intent to place the public or a substantial group of the public in fear of serious bodily injury. So at this point, for this hearing, it is not within my jurisdiction or purview to determine whether or not you made a threat with the intent to do whatever, right? That would be something that a jury would decide. Now, if you were having a bench trial, then I would be in the place of the jury, and then I would listen to evidence and make a determination of whether or not I believe beyond a reasonable doubt that the state has met its burden based upon what's in the indictment. You understand?
Yes, ma'am.
So what I can tell both parties is that, one, there was a warrant. Both parties stipulated that a warrant was issued. Number two, the court is finding that while your communication with the attorney is confidential and private, right? But the exception to that, one of the exceptions, if there's a threat that's being made. So the communication, the court is finding the communication that you had with your attorney, the court is finding that that falls under the exception of attorney-client privilege. So, State, you want to address the defense's other points, please?
Yes, Your Honor, we would start with point number 5 in the motion to suppress, that the statement was not a true threat. The state is offering to the court and to defense what is Garcia versus State, 583 Southwest 3D 170.
Thank you.
All right, and I'm aware of the case, but I'll review it. Thank you.
I have flagged a couple important spots. The First Amendment does not protect speech like this. A true threat, and Your Honor, you will find this, I believe, on page 2, that first flagged one. True threats encompass those statements by which the speaker communicates an intent to commit an act of unlawful violence to a particular individual or group of individuals, regardless of whether the speaker actually intends to carry out the threat. And this Garcia case quotes a Supreme Court case, Black 538 US, and that's at 359. The reason that the First Amendment does not protect violent speech like this is to promote public safety and curb misdirection of resources. When defense brought up Watts, that is specific to the draft. And the gentleman in that case didn't know if he was or was not going to be drafted. So it was hypothetical, hyperbolic. In this case before the court, we heard the recording on Wednesday, 3 times, Wednesday, Wednesday, Wednesday. When the defendant talks about dead bodies everywhere happening on Wednesday, I'm gonna make history. This is not hypothetical. This is distinguishable from Watts. The defendant here is making direct threats. Now, this language is not ambiguous or exaggerated. If X, then Y. When defense says, well, look at the attorney, Mr. Ireland, he did not express fear. He did not interrupt or disengage. In the 12-minute conversation, it was 1 minute and 25 seconds after being threatened by the defendant that his attorney, his own attorney, says, get out of my office. Subsequent to that, this attorney paid for active shooter training for everyone at his office, paid for them to become familiar with guns, concealed carry, locked the doors to his office. The defendant scared this man, and that is the state's argument. This is not protected speech. It was intended to make a response. It does not matter if he intended to carry it out. The intent is to place the public in fear. It was directed to a specific date. We entered that Wednesday court date in the civil courthouse. It was, it was not a joke. It was not to be taken lightly. On that same case before the court, if we may go to page 3, Defense spoke of lack of mens rea. Paranoia is not a criminal element. This conversation was more than exploring conspiracies against the defendant. This was not a private emotional procession or communication with the attorney. This is more than delusional, exaggerated, and distressed. It was a terroristic threat. He was not seeking knowledge. He wanted a reaction. Was it to light a fire? Who knows? But the fear was more than just at the office. It is at the courtroom. It involved the families involved in the civil proceeding. This type of language is not protected under the First Amendment. It is a true threat, and therefore defense's point number 5 should be denied as well.
All right, this is what the court is going to do. The motion to dismiss is denied. The motion to suppress is denied. I'm going to schedule this for a jury trial for September 30th. And so if there are more motions for the court to hear, please bring your motions before that date. Ms. Ferguson will make sure that it is placed on the docket.
Judge, is there any possibility that I can re-urge my motion to reduce bond
Yes.
at this time?
Well,
And
not
I'd
at
like
the-
to ask for that because
Well, not at this time, but if the state has no objection, we can do it later in the week.
The state would object.
All right. So you'll have to give them their 10-day notice. Or, I'm sorry, state, how much time do you need? You need less than 10 days?
For the reduction?
Yes.
We would.
All right. So if you all will confer on a date with Ms. Ferguson.
Yes, Judge.
All right. And then we'll go from there, okay?
Okay.
All right. They may be able to do it sooner. Amanda Ellis. Yes.
For a reset.
All right. Where are you on discovery?
After the discovery, we got an offer today. The way to think about the offer.
I'm sorry. I'm sorry. You said you had an offer?
Yes, today, and we need to think about
Okay. All right. How old are you, miss?
37.
All right, Ms. Ferguson, if you set this in 2 weeks for a plea deadline date, please. And it's Amanda Ellis. All right, August 14th, and you need to make sure you're on time for court. The next time a warrant will be issued. Do you understand?
Yes.
Unless there's good cause. All right, thank you. Once you sign the reset form, you're excused. You're welcome. All right. Just give me a moment, counsel.
Yes, ma'am.
Carlos Perez. Carlos Perez. They're gonna have to come back on another date. Just have a seat, sir. Matthew Stephen Martinez. All right. Fernando Guzman.
I'm here for him, Judge.
Yes. All right, counsel, where are we on discovery?
I believe I have all this everything.
And was an offer tendered?
Yes, Judge.
All right, sir, how old are you?
45.
All right, Ms. Ferguson, I need a 2-week reset on Guzman for a plea deadline date. All right, it'll be for August 14th. What page is he on? All right, thank you. All right, Mr. Guzman, you need to be on time for court next time. Otherwise, a warrant will be issued unless there's a good cause for your being tardy. Do you understand? All right. And if you're drug tested today, what are the results going to be?
I've been taking medication for my surgery. He had bladder surgery, Judge, and that's a big part of why he's late.
Okay.
And part of why we need a reset, just get him a little more comfortable from the surgery.
Okay.
And we expect that we might likely take that plea bargain.
All right. Once you sign the reset form, you'll be excused. Okay. Thank you.
Moses Ross. Is that okay?
Oh, just give me one moment. I'm going through the line. Christy Riojas. David Moses Escobedo. All right, we're still waiting for your attorney. Oh, just let Moses Ross.
Present, ready, Judge.
Are you ready to proceed on the motion?
No, Judge, it's just a bond setting.
Ah,
The one was what?
good morning. All right, is this,
It's family violence, but MTR, but the new number ones are criminal trial judge.
all
I
right,
believe that's, well, family violence gave it to us since it has the new number ones.
all right, the court is calling 2023 CR 3543 State versus Moses Ross. Can I have parties announced?
Jason Garaham for the state, Your Honor.
Nick Aguilar for Moses Ross.
And are you Mr. Ross?
This one.
All right, you are here on a motion to revoke. It's a deferred adjudication, so you're entitled to a bond. Have both parties had a chance to confer on a bond amount?
Yes, Your Honor.
And have parties reached an agreement as to a bond amount?
Yes, Your Honor.
And what would that be?
On each of the cases, Your Honor, a $15,000 bond.
All right, he has two cases.
Yes, Your Honor.
All right, and what are you requesting on each case?
On each case, $15,000, Your Honor.
All right, then the court is also causing 2024 CR 4456. All right, the court is aware of the defendant's history because he's on probation out of this court. So in each cause number, the court will set his bond at $15,000. There's going to be partial GPS, waive fees, and there's to be no contact with the complainant in each cause number. All right, Ms. Ferguson, I need a contested hearing on Mr. Ross. All right, so we're going to come back on August 18th for a contested hearing in each cause number. All right, thank you.
He would like to address you about the partial GPS.
I'm a full-time dad. I don't work all the time. And the reason why I'm in trouble right now is because, can I say that? I got caught with the.
Also, here's the thing. I don't think you want to speak to the allegations that are in the motion. So I'm telling you, partial GPS for employment. Thank you.
And then we signed a reset form.
Yes. All right, Vincent Arredondo.
All right, friends, as Bailey just put it, show 100 in the bag. So I hope y'all had fun today. I did. We'll be back this evening, 8 p.m. Eastern, 5 p.m. Pacific for Sidebar, where I believe we're going to discuss the Judge Mogan case from yesterday's live, where a death resulted in a fairly light sentence. And I think we'll also probably dovetail that into the whole idea of plea deals and how those are leading to lighter sentences and stuff like that. So be sure to join us. Again, 8 p.m. Eastern, 5 p.m. Pacific. There is a link in the pinned chat for that show tonight, so be sure to check us out there. Michael says, no bingo for me. I was so close. Yes, you were one square away, Michael. But maybe tomorrow will treat you better. Speaking of tomorrow, we will be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. Again, thank you so much. 100 in the bag. Let's see what the next 100 bring. So see you all this evening. Take care. God bless.